Any mention? Item number 1.
Item number 1 has been called.
Yes. Yes, Mr. Panthi.
May please, Your Lordship.
I've received the, my lord, affidavit filed by the my lord respondent. It seems they have carried out certain repair works.
My Lord, it's not an affidavit, it's just
It's a
status
status
report,
report,
my
my
Lord.
Lord.
I
I'm sorry.
intend to know.
You want to file a fresh one, correct?
Yes, my Lord, status
Where's the
report.
fresh one?
Yes, my Lord, the status report I have produced. I have given a copy. To
Last time you said Mr. Sengupta has submitted those status reports in file 247. He praised you to 2 weeks.
for a latest status report, my Lord. We have, work is going on, my Lord.
Disruption. Disruption.
This is a report made by you or report made by someone else just given to you?
My Lord, the project director of the National Highway, my Lord, has forwarded this status
It's not an
report.
affidavit, it's just a report.
It's a report, my Lord.
You give
I've just received it, my lord. My lord, kindly grant me some time to examine it, my lord. It seems, as per the photographs, it seems works they are carrying out.
yes, attitude.
My Lord, we will kindly see the photographs also, my Lord,
Yes.
just to show the different types of works which are being carried out, my Lord. Of course, it's a very uphill task and they are doing it, my Lord. It will take some more time and because of the bad weather condition, my Lord, it is not so, the work is not proceeding very fast, my Lord, for bituminous work. But besides that, my Lord, other works are being carried out, my Lord, like the protection wall, the pothole repairing, my Lord. There's
There's
a
a tunnel, that entire hill came around the tunnel. It came around the tunnel, Sonapur.
in several places there are landslides also, my Lord, which is occurring very frequently because of the heavy rain, which is also being
Of
taken
course.
care of, my Lord.
The rains here are brutal anyway. Yes, the detailed status report as allowed by order dated 27/8/2024 has been submitted by the
Project director,
project director. What project director?
National Highway Authorities.
National Authorities of India has since taken on record. Stop. Mr. This paragraph, Mr. S. Panthi Amicus raised that we allowed some time to examine the same and
My lord,
file a
response, my lord,
response.
if so desired, my lord.
After
My Lord, what I beg to
After 2 weeks, my
suggest that,
lord.
there need not be any, let them observe, my Lord. We'll file a status report after
so
2
let them
months.
file a response. Suppose it's not correct. Suppose it has been
Of course, my Lord, of course, my Lord, that will be there, but then
because
what-
they'll do physical verification. He'll get information.
correct.
It's just a matter of the 3 weeks.
Sweet.
Yes, it's not 3 weeks. It's for further orders for response by the amicus.
Obliged.
I'll apply.
Item number 2.
May I please, Your Lordship, may kindly grant 2 weeks further time to file our objection.
What? How many days delay?
292.
92.
What is the matter about?
Some work was carried out for officers and staff quarters in West Garo Hills by a tender floated by the CNRD Department, Community and Rural Welfare, Rural Development. Thereafter, the work order was issued in 2005 and final bill was submitted sometime in 2009. And after that, they did not pursue the matter any further. After 6 years, they issued a legal notice under Section 80 asking for recovery of that amount, and a reply was issued within about 2 months. Again, they waited for a substantial period of time and filed their suit in October 2016. A plea was taken that the suit was barred by limitation. But the court has held that the limitation will be treated from the date of the reply to the Section 80 notice. Patently barred by limitation, my lord.
It's over 12 years.
My lord?
Over 12 years.
Lordship. Because the legal notice was submitted in the final bill was submitted in 2009 and suit was filed in 2016.
Oh, it's not title suit, sorry. Claim for money.
Yes, my lord. Before the commercial court.
Yes. Okay. Then we condone the delay.
My lord, we have objection because the ground which it is stated, it is internal communication, based on internal communication 292 days. And it is a matter of commercial dispute.
Okay,
So
Mr.
time is
Pandit, prays for further 1 week's time,
2 weeks, your lordship.
2 weeks' time to file objection to the condemnation application stop. It is made clear that if the objection application is not on board for next day, the delay shall stand condoned.
I will.
Item number 3.
May it please your lordship. Lordship, I just crave the indulgence of the court. On last occasion, your lordship, I had made a submission on 27 that we received the paravised comment. And now a week's time was given. Lordship, just yesterday, lordship, we have even received an updated status exactly what has happened. So, lordship, kindly just grant us a week's time. We'll file a consolidated affidavit positively by next date.
Mr. K. Khan prays funds allowed AAG, which also prays funds allowed for the 1 week's time.
Lordship, we'll positively file
File
it.
a affidavit indicating the progress of work of the Moplang Balat Road.
Lordship. Obliged.
Accordingly, also.
Hearing item number 4.
Who's that?
The
My lord, I'm praying for.
petitioner in this case, my lord,
Yes, Mr. Why bring for time?
will not,
Mr. Paul
Yes,
is not
my
well
lord,
today, my lord,
petitioner.
so he-
Yes, Mr. Advocate General, what are we saying?
your lordship, the challenge in this.
Oh, no, they are seeking time.
petition is-
They're seeking time
Okay.
on the side of the petitioners. No, that now you're waiting the outcome, the
My
judgment has
lord, that
been
has been delivered, my lord, my lord.
delivered by the Supreme Court.
My lord.
Judgment has been delivered. A power of the state government has been upheld to.
Has been
power
upheld.
of the state government.
My lord, we are
It
examining the
has been
judgment, my lord.
upheld.
My lord, may fix it next week, my lord.
One paragraph is required, my lord. I have placed that judgment.
Anyway,
before you.
Mr. Let them
Last
come.
time on-
We'll give it a decent burial next day. Yes, on the prayer of MS Abdatta due to the unavailability of the arguing senior counsel process matter after 1 week.
Lordship, can you place the judgment on record for court's convenience? We have extra copies.
Yes, yes. Yes,
Yeah, please only copy.
Mr. K. Khan, however, appearing for the together with Advocate General, prays that these respondents may allowed to place on record the judgment rendered by the Supreme Court on regard to a same subject matter. Yes. Praise allowed, yes. Submitted. Put it on record.
Yes.
Come for the next date.
Supplementary list. Item number 1, pronouncement of judgment.
Very interesting case. But Procedural law, in fact, having heard the concept of the parties, this court notes that the primary challenge of the petitioners, the application for probate, is firstly that both the plots mentioned in said will have been conveyed by way of sale to so and so, the petition number 7, as far back as in so and so and so and so. At the time of execution of the will, the testatrix, and at the time of execution of the will, the testatrix no longer possess any right or title of the same. The other main objection raised is that even though assuming but not admitting that the will dated so and so has been executed with testatrix, the same should have been presented for probate by the due upon executor, whereas the person who applied for probate was beneficiary, that is respondent. The other challenge was that the will is a false manufactured document. The testatrix was an illiterate person and could not have written the purported will. In the background of these circumstances, this court is to discern as to whether the challenge to maintainability of the application of probate is limited to question of law only, or whether it's a mixture of law and facts. First, it to be noted that learned court below framed an issue, as observed earlier, as to whether late so-and-so and a purported will had appointed one so-and-so as the executor. The fact that this issue has been framed shows that the probate court itself, on the challenge to genuineness of the will, has also deemed it necessary to determine the factor of appointment of the executor, which would rest on the test of the genuineness of the will, genuineness and validity of the will. As such, the situation with a very important question as to genuineness of the will hanging in the balance, which needed to be tested by evidence, the issue of the will having to be presented by named executor by application of section 222 of the Indian Succession Act does not assume great significance, as it would have to presuppose that the will was genuine to warrant the rejection of probate application on the ground alone. Another aspect which the court has noted is that civil suit with regard to the two plots mentioned in the will are pending on being instituted by the petition number 7 for declaration of right title interest on the basis of the sale said to be executed by so-and-so testatrix in favor of petition number 7. This fact will necessarily have to be taken into consideration in the process of determining as to whether the will was validly executed or whether the same is contrived and manufactured as alleged, and also can only be through the adducing evidence. The judgment dated so-and-so as place of the Bombay High Court testimony suit has reiterated and digested the various judgments of the High Court Supreme Court apart from commentaries thereon, wherein settled law, the jurisdiction of a probate court is limited to the aspect of valid execution of the will and so it decides its issues pertaining thereto. In the given facts and circumstances of the case, therefore, and as discussed above, the challenge to maintainability of the probate petition not being confined only to a preliminary issue that can be disposed of on an issue of law only, as both issues of law and fact have arisen, the instant revision application fails and appeal order so and so is upheld.
Sure.
Yes. No one for the respondent is not here. Yes.
Any mention?
May it please your lordship.
Yeah.
Your lordship, I beg to mention item number 32. Your lordship, this is a VEC matter. On the last date, the petitioner had a...
Yeah.
Your lordship, on the last date, the petitioner had apprised the court that the president of the VEC had resigned. However, your lordship,
Number
that
32.
32. Your lordship, the concerned officer here has not received any information regarding the resignation. Lordship, we have produced a letter with the signature of the president that she has resigned with the reason that forging my signature and unlawful drawing money from the scheme fund by the secretary of the VC. Lordship, I pray for some time since the resignation.
You supply copy, MSLE says that now some time to ascertain as to whether the president or the VNC has really resigned.
Yes, your lordship.
Next, MS M. Rahman, however, has produced a document ascertaining which he submits ascertain this fact. A copy being made over to the learned common advocate just after 2 weeks. Yes.
Obliged, your lordship. Much obliged, your lordship.
May I please, your lordship? Your lordship, I'd like to mention item number 20, your lordship.
Number?
20. A week's time, your lordship. I'm praying for a week's time.
Why? Who's for
Lordship, a little bit,
main respondent?
the Office of Accountant General Audit.
You're the main respondent.
Yes, Your Lordship.
Yes.
Lordship, I have objection because this matter is pending.
Okay, objection, we will take it up.
Small difficulty, Your Lordship, is may be listed on Friday, Your Lordship.
Friday, no, court won't be there.
Monday.
I mean, second half. Yes, okay, Monday.
Lordship.
Mention is made on behalf of the respondents for today's adjournment. MS Prasad. The respondent has, however, on the same day objected to list the matter on Monday. So anything else?
My lord, I beg to mention item number 21, my lord. This is a contempt matter. I filed a review petition, my lord, which most probably either Monday or Tuesday, my review petitions will be coming up.
Petition.
My lord, this here directions number 3, my lord, which I've said it become impossible for us to perform, my lord. So therefore, we were seeking review of that.
Why, what was the condition number 3?
The direction number 3 was to pay the salary for the period when the incumbent teacher remained terminated,
But
my
that
lord.
was your proposal only?
I'm sorry, my lord.
5,000 per month?
No, my lord. That is the different case, my lord.
Oh,
Here.
sorry.
Yes. So on the last occasions also, I've sought time for file. The review petition has been listened.
See,
My lord.
something that's not born yet, you can't take, you know, an excuse for that.
My lord. I understand, my lord.
That I'm just about to win the lottery, so the payment will be deferred. Or like I'm about to get some money from.
No, my lord,
from
because my lord, because here what happened is, my lord, even 196.
How are you sure that your review will be accepted and the judgment reviewed?
My lord, because here what happened is, my lord, it has become an impossibility for. It's not that it's not our refusal not to pay, my lord.
No, how are you sure the review will be accepted? The contempt was filed when since 23.
My lord, 23. My lord, because we have made all our endeavor, my lord, before and subsequently she has also resigned, my lord. We have complied. We have given her
What
back
is the
the
period
job.
of salary you're supposed to pay her?
My lord, that is from
17,
2017, my lord. 2017 till 2024, my lord.
What is the salary?
2022, my lord.
20, my lord, it will be around 10.
2017 till 2022.
What is the salary you were drawing?
20,493 rupees, my lord, per month.
20,493 rupees.
My lord.
It's
How
coming
much
to
will it work out to in
it's coming to around
5 years?
12 lakhs, my lord. It's coming to about 12 lakhs, my lord.
So what was the difficulty? If she's worked for that time, that's her entitlement.
No,
That's
she
her
did
right.
not work. She did not work for that period, my lord, because
Found that she should have worked also. Then it's
They terminate me that time, my lord.
Yes. What do you say?
They terminate me this time,
Then
this period.
you work it out installments.
my lord. Otherwise, then let it come up. I'll wait. We'll hear it today, my lord. Review petition I can withdraw, my lord.
We'll wait. Then those people who have committed contempt. What are you going to do?
Because, my lord, there is no deliberate, my lord, and we are not refusing not to pay, my lord. Even the direction,
going to jail, Mr. Yuban,
my lord,
you just have to comply with the order.
my lord,
Help anything.
my lord, I understand, my lord. What something when it has become impossible for us to comply, my lord. We have complied 2 directions, my lord, and 1,96,000 that we have given also, my lord. We are paying. We have taken on loan, my lord, that amount also. We are a very small village, my lord, and all the family members are under VPL. We are not getting any grant in aid, my lord, except for 2 teachers that are under SSA, and the conduct of the teacher itself, my lord. Of course, I am in a too late stage to raise this kind of issues, my lord. But all I'm saying is, my lord, we have reached a stage where, my lord,
Impossible to pay.
It has become impossible for us to pay, my lord. We have reached in that stage. That is the reason why I was asking, my lord.
Okay, we'll have it after 2 weeks.
My lord. I am deeply obliged.
Give it 2 weeks here from the request also. Yes.
With this, Your Lordship, I'd like to mention item number 26, Your Lordship. I humbly pray, Your Lordship, that a matter may be listed after 2 weeks, Your Lordship. The conducting council is on listed after 2 weeks, Your Lordship.
Why?
The conducting council is on sanctioned leave, Your Lordship.
You're a conducting council now.
Lordship.
What's the matter about? Salary?
No, Your Lordship. Matter, Your Lordship.
Then a salary they have difficulty in doing because they can't pay. This arcing matter, what is there? Who's in office? You're in office or you're in office?
No, Your Lordship, we for the private respondent, Your Lordship.
You're in office. Who's in Okuma? Karan Okuma. You're a Karan Okuma.
Yes, Your Lordship.
Okay, after 1 week, yes.
Much obliged. Your Lordship, similar prayer for item number 17 also, Your Lordship. We have already taken consent from the other party, Your Lordship.
Yes, Mr. Sheikh.
Yes, Lordship.
2 weeks, okay, yes.
Much obliged, Your Lordship.
Lordship, back to mention item number 18, Lordship. Conducting
Okay,
counsels
yeah.
in bereavement, Lordship.
On behalf of?
J. Shalla, Lordship. He's currently
No,
bereaved.
respondent number one.
And for the petitioner, Lordship.
Petitioner.
Yes, Lordship.
Yes, who's the paying correspondent?
18, 19.
18 and 19, yeah, same, Your Lordship.
Yes, Dr. Mozika. Here for the council. Anything to say? Have you been paid? Have you been paid?
Lordship,
Up to what month?
Till December 23, Lordship, as per the instruction.
Okay, let's after 2 weeks and
Apply, Your Lordship.
May I please, Your Lordship, I beg to mention item 23.
what's the matter about?
Is a service matter where the petitioner was denied his promotion?
Seniority, my lord.
Promotion.
Seniority.
Promotion.
Seniority, my lord.
Where's Mr. Changreso?
He's on legs, Your Lordship.
No agency.
Your Lordship, I'm praying for 2 weeks' time, Lordship.
3 weeks, no agency.
And for the
yes.
state respondents, my lord.
I don't touch.
I'm for respondent number 4.
Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 22. Lordship, I'm praying that this matter may be listed after a week's time.
Where's the who's for the respondent?
My lord, for the state, Mr. H. Kharmi is for the state, my lord.
Karmi.
Yes, my lord.
And for the private respondents? General.
Yes, yes.
No objection.
No
No agency.
No,
Up to 2 weeks, yes.
Lordship, highly obliged.
Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 28.
28.
28. My lord, kindly have the matter after 2 weeks.
No,
No objection.
No. Item 29 also, Your Lordship, is
Yes, Commissioner, connected one.
Okay, 2 weeks, okay.
Feebly obliged.
Yes.
Lordship, I'd like to mention item number 15.
Number?
15. 15.
Ring. On whose behalf?
Titi Ding Dong.
16 connected to 15.
Yes.
Yes, Mr. Nyota.
No objection.
Matters is images. Let me get someone argues. When 2 weeks? 2 weeks, I think 2 weeks. Yes. Yes.
All right.
Supplementary list item number 2.
It's a petition under section 11 for appointment of an arbitrator, my lords. The
We are
disputes
taking notice. Yes, okay. Your name?
Risha Mittal, my lords.
That's heard MS. Also the petitioner issued notice. Dr. N. Mozika's letter DSGI with so-and-so present express notice on behalf of all the respondents. No further notice called for. It's up to 3 weeks for instructions of the affidavit. Yes.
Grateful.
Item number 3.
May it please, Your Lordship. Your
Yeah.
Lordship, in this matter, Your Lordship,
The petitioner was working as a constable, Your Lordship, in 6th Battalion, Meghalaya Police, Your Lordship.
Constable.
Yes, Your Lordship.
Okay, what
He was
happened?
in service for 11 years, Your Lordship. Your Lordship, DP
What?
was, he was in service for 11 years, Your Lordship.
When was he appointed?
He was appointed in the year 2011, Your Lordship, 16/11, 2011.
11 years.
Yes, Your Lordship.
Okay, then.
So, Your Lordship, after that, the DP was conducted, Your Lordship, against him.
Why DP is conducted against
Two
him?
charges, Your Lordship. One, he was found intoxicating, Your Lordship. He was found creating nuisance while intoxicated. And the second charge is, Your Lordship, unauthorized absence for 500 days, Your Lordship.
How many days?
500 days, Your Lordship.
500 days.
That was his past antecedents, Your Lordship, which was already condoned in the earlier DP, Your Lordship. So, Your Lordship, being aggrieved by
No,
that,
what is meaning the delay was in the fresh DP? Days.
there was a delay, but not 500 days, Your Lordship. The 500 days was his past antecedents, Your Lordship. So, Your Lordship, the impugn order was passed, Your Lordship. It was imposed with a major punishment, Your Lordship, which was dismissal from service. So, the impugn order is at page 40, Your Lordship, which was passed by the
40.
respondent number 4, Your Lordship.
Page 50.
Page 40, Your Lordship.
Yes.
So, on two charges, Your Lordship, he was dismissed from service.
$500 days. Yes. How do you say that it's condoned?
Your Lordship, it was condoned in the earlier DP, Your Lordship, which was initiated against him, Your Lordship.
You're dismissed from service.
Yes, Your Lordship.
You file appeal.
Yes, Your Lordship. We have filed an appeal before the respondent number 3, Your Lordship, which is at page 40, which is at page 46, Your Lordship.
Dismiss.
Yes, Your Lordship.
Yes. But when was he dismissed? Okay. Anyway.
Your
But
Lordship.
MS LD Sangma, the counsel with the petitioner, issue notice. MS NG Shilla, Leonard Advocate, except those have all respondents.
All the respondents, Lordship.
Called for just after 3 weeks for affidavit is.
Much obliged, Lordship. Highly obliged.
Item number 4. My Lord, may kindly take it up, my Lord, tomorrow, my Lord.
What's the matter about?
This is regarding, my Lord, the petitioner is cheated, my Lord, through online transaction, my Lord.
This Seema Bhattacharjee is the advocate.
My Lord.
Why is not doing herself? You got cheated by whom?
Through online transaction, my Lord.
Online cheating.
Yes, madam.
And my
What
Lord,
happened?
after that, my Lord, after filing FIR, my Lord, the money is retrieved.
Money is retrieved. Then
Money is retrieved, but my Lord, on the next date, my Lord, the money is again withdrawn by the bank. So,
after the
as of now,
okay, she was cheated. Then she made a complaint.
my Lord,
Then the bank
has
repatriated
retrieved the money, my Lord.
Yeah, retrieved the money.
My Lord. After that, on the
Given
next,
back to her account.
my Lord,
And then?
on the next date, my Lord, again the money is disappeared from our account,
How is that possible?
my Lord.
Let us see. Where's the FIR?
That is page number 19.
19, my Lord.
Why you want to do it tomorrow?
My Lord,
You have to do it in her presence. It's not here
no,
today.
my Lord, Mr. Paul is handling this case, my Lord. So, my Lord.
Notice has to go, my lord, anyway to private.
My Lord, let it come up tomorrow, my Lord.
Oh, this is Annexure 1.
Annexure 1, my lord.
Annexure 1 is the transaction, my Lord.
2 is, my lord,
He paid
the
whom? He paid a certain person.
My Lord.
yes.
It was fraud.
It was a fraud.
FIR is at page number 21, my lord.
Through GPay. Was he contacted over message or by voice call?
Voice call, my Lord.
Voice call.
My Lord.
They could.
Impersonating as a senior counsel, Mr.
How? I mean,
Nikhil Sindhal.
the voice was.
Exactly like him, my Lord.
That's very dangerous.
My Lord.
I can understand the text messages, but through voice call,
My Lord, around 99,000.
and she was fooled.
Let it come up tomorrow, my Lord.
Yes. Where's the general? The voice can be cloned. Then this is matter on the premise of the unavailability of arguing here this matter tomorrow. It's very dangerous if through a voice call I can understand, like what happened even from my account. I mean, like my WhatsApp. Oh, you're here. I didn't see that. It went, to the registry, to the officers that to buy Amazon gift cards on, and my picture and thing. But the number was from Kazakhstan or something. But that I can understand. But then voice, the voice was Mr. Jindal's voice. You sure about that?
Yes, Your Lordship, I checked in the WhatsApp also. His DP is also set in the WhatsApp. Then, and after
It's a WhatsApp call.
Yes, Your Lordship.
And it was his voice.
Yes, Your Lordship. Otherwise, how could I, even I, after trying.
Deposit money.
No, because he first asked me whether do I have GPay. I said yes, sir. Then he said, तू बोल के तेरा अकाउंट में मेरा क्लाइंट का किसी को पैसा भेजना है, कोई बीमार है तो तू ये पैसा ट्रांसफर कर देना, शाम को हम पैसा वापस कर देंगे. Exactly the way sir speaks.
Cloned his voice. Very serious thing.
Account is blocked. I blocked the account from the bank only, but when account is blocked, money is retrieved because I filed complaint to crime branch also, and they locate the number also from crime branch. It is in Delhi. From the number is from Delhi, and thereafter
the number the call is from Delhi.
Yes, they said it is from
that
Delhi.
Voice call.
Voice call. Yes, yes.
But it could be traced or it could
Money
be
by
VIOP.
the bank. I lodged.
It is voice over internet or it's a voice over
Normal
internet
call.
protocol.
Normal call.
It's a normal call.
Normal call, not WhatsApp. But I was asked to put some number in the GPay, and that name of one Barik, Vijay Barik appeared in the GPay number.
Very strange. Yes.
But after the money is retrieved, after retrieval of money it was deposited in my account. I have taken out the statement, and next day again money is not withdrawn because when the account is blocked, debit option is blocked by the bank itself. How they withdraw the money without my consent.
So the bank also
Now
could not
only
stop,
it is against my complaint is against the bank only.
no, the bank could not stop even after your company could not block the money.
It was blocked, my lord, from 8.
It's retrieved. I mean, after retrieval, you could not block. Your account was blocked.
No,
Even then they
from
took it.
8th onwards, the incident happened on
No,
8th.
we understand. The thing that now that means after retrieval, you had blocked the account. It
My
become inactive.
No,
And even then, amount was
credit
taken out.
option is open, but debit option is blocked from since 8.
We understand, yes. I mean, that's the thing.
But it is withdrawn by the bank. No one has access to the account. Even I cannot withdraw money also.
Which bank is this?
HDFC Bank.
No, it's very dangerous if if a voice call comes.
Right.
And how can impersonate? It must be a known person. Yes.
Item number 5.
My lord, for similar prayer for item number 5 also, my lord. Let it come up tomorrow, my lord.
Number 5 is what?
See, this is without petition, no? Not wrong.
Yes, same for tomorrow.
Blessed.
Obliged.
Item number 6.
May it please the lordship. Is a matter, my lord, where land compensation has not been paid to the petitioners, my lord, is extension of Tura Dalu Road, my lord. Let notice be issued, my lord.
Who are you here? Landowners?
Yes, my lord.
You are valid landowners or did your name appear in the notification?
Yes, it's there, my lord. But payment has not been made, my lord.
His name was there in the.
It appears so. That is a statement, my lord.
Yes, Mr.
Perhaps the prayer now is only for payment of compensation. I think it's too late in the day to challenge the proceedings per se. And may I also just point out, one of the challenges is to a letter. Just kindly have the prayer for a moment, my lord. At page 32.
Yes. Impugned notice void memo. What is this?
At page 32.
Yes.
Prayer number B. Caution set aside notification dated 24/6/2019 issued by the
question
by the DC. If your lordships will turn to page 126, they're referring to the section 11 notification. So at page 126 is this reference to 24/6/2019. This is only a forwarding letter. And if your lordship see at page 127, this is the draft notification. This is not actually what was published. They might have to correct this, my lord.
The examiner
We will not like to press those, my lord, if I get them my compensation. Right, so we'll take instructions.
Mr. SD learned with the petition. If you notice, Mr. S then present, except those will be out all the respondents.
No, my lords.
Let me out of
1 to 7.
1 to 7. Notice to issue to respondents number. That is.
So the rest I will take note. Stats, my lord.
No, what up? No, this is Dr. Mbozika won't take for 8.
We have served. We have served it. We have not served. We will serve them, my lord. A copy.
Number 8 is Secretary to Government of India. Yeah, Mr. Agents also, Mr.
8, 9, 10 will serve.
We have 1 to 7. Dr. Mbozika number 8 that will issue. What about the Director General Meghalaya Institute of Governance?
So, MIG Mr. Gautam appears in other cases. For 11, my lord. 11. So I will serve him a copy, my lord.
For 8, 9, 10.
That issue notice to. Yeah, 8, 9, 10.
8, 9, 10.
Then only 11 remains. Mr. Essence present except rule to 7. Dr. Mbozika on behalf of 8, 9, and 10. And that was issued on 11 within 3 days. Just after 3 weeks is instructional activity.
Daily list item number 1.
We make the payment over the Yes.
To item number 1, we would like to file an objection against the appeal, Your Lordship. So, Lordship may grant us 2 weeks' time to file our objection.
On what grounds objection? On what grounds?
Lordship, for that we need to seek instruction, Your Lordship.
One objection, you have to know on what grounds it is. What grounds you want for
Lordship, in
objection?
regard to the
It's for admission.
appeal, Your Lordship.
Yes.
My lord, when initially the matter was heard, my lord, we were directed to deposit an amount of 1,50,000. That we have deposited, my lord. 1,50,000, my lord.
Yes, Lord. It has
So that we have deposited, my lord. What I pray, the appeal may be admitted, my lord. The interim,
Who is appealing for the respondent?
they are the respondent, my lord.
Then we'll admit the appeal session.
My lord, what I pray, the appeal will be admitted, my lord. The order may be stayed since we have deposited the money. Last occasion, no one appeared, so no order could be passed on last occasion, my lord. The previous order, kindly see.
Miscase for what? Miscase number 1. Miscase number 1.
For stable.
Yes. Okay, yes, for Dr. Mbozika, counsel advocate for the appellant is submitted by the senior counsel that the amount is directed to be paid into registry of this court, that is 1.5 lakhs, has since been deposited 1/2/8/2024. Accordingly, admit the is the first appeal, right? Justice where's the first appeal? Accordingly, the MAF number stands admitted. Stop. In this case, pending further pending hearing, the impugn order dated
22/5/24.
is Dr. Mbozika and so and so. Japneet Singh or something for the respondents. Yes, this is by this application, the appellant was placed for interim order stating operation of order dated 22/5/2024, passed by learned Sikh Judge Boy, District Nagpur, in this case number 1/2020, for the reasons shown therein, hearing the parties. The impugn order shall remain stayed till matters heard. Yes. Understood. I asked you order, one of the positive was admit and then miscase. Yes, that is further.
Item number 2.
May please, Your Lordship. Well, I'm appearing on behalf of Mr. D. Sahu, my lord. He has some personal difficulties today, my lord. I'm paying that may be adjourned for a day, my lord.
Can't
I have
see
also
anybody.
informed Lions yesterday.
Where is submitting from?
My lord, I'm from VC Masam. There is some glitch in the video, my lord.
So where are you?
My lord. I'm in, sir, my lord, VC.
No, where are you? In Guwahati or where are you? Where are you from?
Guwahati, but in Guwahati.
What to do?
Well, here we are challenging the maintainability before this honorable court. Cause of action arose in Tripura, my lord, and the writ petition is filed here.
I'm praying that maybe adjourned for a day only, my lord. Mr. Sahu has some difficulty, my lord. He is not keeping well today, my lord.
Then who'll come argue the matter tomorrow? When you also can't be seen. Yes, this is the matter for 1 week. Yes.
Oblige, Your Lordship.
Due to technical issues, the matter cannot be taken up effectively just after 1 week.
Item number 3.
Please, Your
Also,
Lordship.
we have prepared the summon. I may be allowed to give it in the course of the day, Lordship.
Your Lordships, there is a small submission to make. Your Lordships, evidence affidavit has to be filed prior to.
You're not filed this yet.
We'll do it in the course of the day, Lordship.
Course of the day means what? Summons and everything.
Lordship, we'll do. It's all prepared. We just need this. Waiting for the signatures, Lordship.
Mr. Where's the application? How do you expect this court to file to pass the orders for everyone application?
No, I'll file it today. It's a Lordship. I have it all prepared in the.
Okay. When the matter is taken up, the Mr. S. Deb, the counsel for the election petitioner, submit that the evidence on affidavit as well as the summons copies shall be filed
today
before the registry in the court of the day. Then when you want it?
Lordship, whenever date convenient, Lordship.
Summons, but then summons is
as per the date which is set. Next week, Lordship.
When
next
when
week.
you want to talk about taking of evidence?
Next week, Lordship, 2 o'clock, second half.
Your
Next
Lordship, a
week after
copy
2
of
weeks.
evidence affidavit is to be supplied to us.
To the
from
supplier
Court
it
of
is.
After 2 weeks, Lordship.
We have to take it to October. Then we'll give you dates in 22nd, 23rd. How many witnesses do we have?
Lordship, we have 5, Lordship.
5 should be done.
1 day should be enough, Lordship.
Yeah, list the matter on 22nd. No, fix the matter for recording of evidence on 22nd.
Lordship,
Yes. And if necessary, to be continued the following day, that is 23rd October 2024. Yes.
Lordship, I also have a prayer that the written statement may be closed, Lordship.
Maybe?
Written statement may be closed. They are not filing a written statement nor any application to extend the filing of written statement.
That works the advantage.
Lordship, it may be closed, Lordship.
That works the advantage. We can't.
Item number 4.
You have to file an application for that also.
We'll do that.
Item number 4.
You can petition anything you want.
In fact, they should file an application to extend
They are not
time,
filing that
Lordship.
that goes
Yes.
against them.
Obliged, Lordship.
Grateful, Your Lordship.
Hi, please. My lord, I'm entering appearance for respondent number 1 here, my lord, because only respondent number 1, my lord, has received the notice. Other respondent have not yet received.
Who's the other respondent?
Other respondent.
They are the sons of the respondent number 1 only.
The son.
They stay in the same house. No, not same house. My
Still
lord.
same house.
My lord, respondent number 3 stays.
You're not talking terms with your son.
My lord, respondent number 3, my lord, stays separately, my lord. And
Where does he stay?
respondent number 2 stays with the mother.
Your number 1 is Zahida Begum.
Yes, my lord.
These Arif Ali and Tawfiq. What is the rule number 5 basement floor?
This is the suit premises, Your Lordship.
You can represent them also.
Yes,
Lord, I will take instruction, my lord, if they.
Mr. N. Sincon today has entered appearance on behalf of respondent number 1 and submits that the respondent 2 and 3
2 and 3, my lord.
have not been served.
No, my lord.
If they've been served,
Yes, we have taken steps, Your Lordship, then we will just find out.
Yes, Mr. S. Pandit submits that steps have been taken and to his knowledge have been served. He is allowed to obtain status. Verify this after
1 week, Your Lordship,
3 weeks,
because
my lord.
1 week. It's okay.
My lord, 1 week will be too short period, my lord.
1
I
week
will-
only for ascertaining
My
whether
lord.
he
yes,
will
Your
serve or
Lordship,
not.
my execution petition is also pending. Your Lordship.
Obliged.
Execution petition.
Obliged.
Item number 5.
Please, Your Lordship. I've received a copy of the affidavit by the private respondents. I require about 2 weeks' time to file my reply, my lord. A rejoinder.
We have filed our affidavit, Your Lordship.
Yes, and page 4 is allowed. How much time?
2 weeks' time.
File counter rejoinder to the affidavit by the respondent number.
To all the respondents.
4. We have 1, 2, 3, Your Lordship. 4 is a private respondent.
Yes.
Like,
Item number 6.
Yes, Mr. P.
Lordship,
Kama.
I'm appearing on behalf of respondent number 1. I'm praying for 1 week time, Lordship, to file my objection.
You already took time last time.
Lordship,
How many days
we
was
are
the delay?
preparing the objection. We require just 1 week time, Lordship, to file.
How much delay?
This is only 800 delays.
We'll restore it. It is 1,060 for restoration.
Because dismissed and default during COVID.
On merits.
On default, Lordship.
On default.
When was dismissed for default?
First February 2021.
1st February 21.
On behalf of District Council, we have no objection.
Yes, why not filing?
Lordship, we need 1 week time, Lordship. I'm praying for 1 week time.
At the last chance, 1 week per time granted to the respondent number.
Number 1.
Number?
Respondent number 1, Your Lordship.
Number
Private
1,
respondent,
yes, to file objection upon his application. But if you don't file, we'll condone it next day.
Item 7.
Multiply, Lordship.
In this matter, they have filed the affidavit, Lordship. They are saying that they are admitting that revised pay have not been paid. They are saying that there is a difficulties or financial problem. So I'm saying that my submission is that whatever that due they are admitting, let it pay within some time, because they are saying that the ground they stated that there is some financial difficulties with the JCTC, but they have admitted that the revised pay has not been. They stated some amount has been paid.
Where's the affidavit?
So we have filed it yesterday.
In that para 7, they need to have stated, Lordship.
If I may pay, the matter may be taken up next week, Lordship, because here there is some confusion as to the entitlement, Lordship, because her prayer is that she has not received anything, whereas the affidavits which we have filed, Lordship, says that she has received some benefit, only some revised calculation is.
See, para number 7.
Yes, para 7. I'm not disputing to that. That revised, let him pay to that because.
No. Now what is in the prayer? They have not got
Yes,
anything.
of course. In my prayer, I have stated the gratuity and other.
No,
allowances,
let's
but-
see.
Yes, Lordship.
Whether you misled the court or not. Yes.
That is prayer page 9. I stated in that prayer number 3, Lordship, the gratuity, debtors, allowance, arrears, and terminal benefit. But they stated that only gratuity is remaining, but other they are stating that others they have paid.
See, Mr. Sangma.
Yes.
You have received everything except your revised gratuity and revised arrears of pay. So you've said that to pay the gratuity or arrears
this
term
was-
benefits.
Yes, this was paid after, of course, I got instruction, but this was some amount.
So when you file a petition,
No.
petition said that
After filing of the petition, they have paid. Before filing of the affidavit.
Okay.
So that means only after filing of the
for hearing, yes.
Lordship.
Up to 2 weeks.
Lordship.
And you come up with what amount? What's still due?
Yes, because I will ask you.
Everybody joined or no?
It's not required, Lordship. I will just get the instruction how much I have.
Come with the correct information.
Yes, Lordship. Lordship.
Yes.
Item number 8.
Lordship, this matter can be, I think, can be disposed, Your Lordship, because even the AG, they have filed the affidavit. In the affidavit, they are saying that once the paper received from the government, they will process the matter. They have, yes, that is the only statement.
My lord, in my paragraph,
Para 7, they have admitted, Lordship, in his affidavit.
some time maybe.
Because time is, yes, time frame can be.
Wait, let them submit also. No, you can't submit on behalf of the petitioner, on behalf of the respondent, on behalf of all the respondents, that my petition have said this, the affidavit have said this. You know, then they don't need to appear anymore. In someone's cases, if they file affidavit, are you both sides?
Say, Lordship, because
take decisions on their behalf also then.
No, he is asking time.
Page 3, lordship. Page 3. That's top lordship. And he was released by the block development officer by release order so and so, where the disease has served till he passed away. So further, it may be stated that the respondent already initiated the process for release of family pension and other pensionary benefits of the petitioner. Para 7, lordship.
Yes.
Because of some discrepancies, lordship. In fact, we have taken step.
No, one thing, has it been corrected or discrepancies still exist?
It has been corrected, lordship, rectified.
Okay, then take down. In this matter, whereby he died.
He died.
Whereby the writ petitioner has prayed for appealed for the release of the family pension and other term benefits of the deceased employer who is stated to be husband. Former and after it has been filed by the state respondents, wherein it is indicated that the process for release of family pension and the pension benefits have already been initiated. The 11 paragraph in affidavit for the sake of convenience are reproduced here and below. 11 paragraphs, namely paragraph 6 and 7, so the convenience are reproduced here and below. So, in view of the statement affidavit, that the process has been initiated, and also in view of the respondent number 4 affidavit, what do you say?
Lordship, you yet received the documents, Your Lordship.
And you're processing it. Where is that?
In our next year.
Para?
The next year, para 2, line number 3.
And in view of?
Para 6.
Annexure?
Next year, 1, Your Lordship.
Not received the pension papers. No, not one. Huh? Last line, no? No, uninitiated. It is expected that the same shall be completed most expeditiously. According to this matter, insufficient disposed of with direction that entire process to be completed and the papers submitted to the respondent for process of payment within a period of 4 months.
3 months.
Make it 6 months.
Plus 6 months will be
Maybe
too
4
low.
months, yes.
Yes, Lordship.
From a date and from date it was ordered. Matter according to dispose of. Similarly, for both the product.
9.
Lordship, here I yet to file the affidavit of service because they have received, we have got the information, I think somebody is appearing, we don't know, but the notice has been received because we have checked it. I'll be filing the affidavit of service.
I don't understand what you're saying.
The respondent, the additional respondent number 7, notice has been received. We have checked it from the post office.
Your Lordship, I am entering appearance on behalf of respondent number 7.
Who's respondent number 7?
I'm the
It's
first
the private
right.
respondent, my lord. Private respondent.
Okay, MS CB Savian.
I will file the Vakalatnama in the course of
on behalf of the newly implemented respondent. Number 2. If you have sworn the Lord, how much time to file affidavit? To file affidavit?
Yes, Your Lordship.
How much time?
Lord, 3 weeks time, Your Lordship.
3 weeks time to file affidavit. What about the other? What about the other?
Government we have filed.
Government we have filed, Your Lordship.
Yes, this after 3 weeks for affidavit respondent number 7. You're a second wife. Something like that.
I'm the first wife.
You're a second wife.
I'm second wife.
Article 10.
Much less, Lordship.
Most of the cases are delay pension, apart from Garul's council, from the state, is always on this. One wife, second wife, his third wife.
My lord, in this case, we are awaiting instructions. But my lord, we have taken up the matter with the office of the Director of Health, my lord.
What is the matter about?
My lord, this is regarding the contention of the petitioner, my lord, is that he has donated some land. Now, in lieu of that, my lord, no job is given. He's at this point, my lord, he's seeking compensation. My lord, our contention, this is the second round of litigation.
Not compensation.
But our contention is that in lieu of the land, a job has already been given. And earlier, a writ petition was filed in the same line, my lord.
Lord, they're challenging my service after 22 years.
Who are you?
He is the beneficiary, my lord. In lieu of the land, he is related.
Then who are you?
He's the nephew.
My lord, land was donated by me. In the first round of litigation, they said that we have given the job to Mr. X, and he is not related to me, lordship. Land was given by me, but job was given to them. And
you are the person donated the land.
No, I have donated the land, lordship.
Who are you?
We are related. Me. My father and the petitioner are brothers. Our brothers.
Exactly.
So no two.
He's your nephew. He's got the job.
He is not my nephew, lordship. I am disputing. Let the time, Lord. Two people were appointed. One is his daughter.
Yes.
One was me.
Yes, my lord.
Now after 22 years, my lord, he is challenging my appointment.
What happened to his daughter?
Daughter is still working, lordship. Daughter is for another plot of land, lordship.
Exactly, my lord.
That daughter is for another plot of land. But so far as this plot of land, it is already mentioned in the appointment letter.
So at that point of time, he didn't object to his appointment.
No, we are not ever, lordship, because this is there.
After 22 years, then you have no.
Only after filing the affidavit, lordship, they have placed in record that saying that no, so far as this plot of land, we have given the job to your nephew. Let them to file the affidavit.
You can't ask the government to keep on giving jobs like that.
Not only that, my lord.
Delay and latches. Let them to file the
Apart from delay and latches, my lord, this
take instruction, will dismiss it.
My lord, this writ petition is barred by the principles of res judicata, my lord. These same issues were before the
file affidavit then.
Let them to file affidavit.
Otherwise, you need to file with disposal of now.
Let them.
So I'll require some time, my lord.
1 week's further time is allowed.
Lord,
On behalf of respondent to 4.
Lord, may I pray for 2 weeks, my lord? Because there are two DMH.
These kind of matters, there's 5-minute matters.
My lord.
11.
The respondents are yet to file their affidavit.
What's the matter about?
But this is
Regarding land acquisition, my lord.
land acquisition.
Land acquisition.
Oh, that matter.
My lord.
Has the state filed affidavit?
No, Your
Not
Lordship,
yet.
we're waiting instructions.
But I'm appealing for 4, 6, and 7.
Only that plot of land only of yours.
My lord.
My lord, interim order has been passed, that is causing some difficulty. My lord, only one thing I wanted to point out, my lord. Lords have kindly seized the petition at page 27. My lord.
Yes.
My lord, this is the notification. At serial number 4, your lordship will find Megongri Aking, my lord.
Yes.
Now on the next page, my lord. At serial number 16, petitioner's name is there, my lord, Victoria Sangma. Now the only question is whether our land is within the right of way on the both sides of highway or not, my lord. But the name is already there, my lord. So it is not a case that they are totally left out. Now the question only remains whether, if at all, she is entitled to any compensation, and if yes, how much. My lord, that aspect there is a.
Let them file their affidavit.
That's not her prayer. Her prayer is different. Her prayer is that she was asked to.
We are challenging that notice of vacation, my lord, by the Deputy Commissioner.
Do I remember correctly?
Her page 38, my lord.
Notice dated 15/7/2024.
You file affidavit and dispose of. The quicker you do it, it works better for you.
A week's time, my lord.
Yes, a week's
Your Lordship, I'm
for a
going
time
for
as
2
great.
weeks' time.
1 week's time.
2 weeks, Your Lordship.
I'll place instruction within a week, my lord.
Yes, okay. Dr. was briefed for 1 week to place instructions, whereas Dr. MSZE Nongari for 1 to 3. Dr. Mbuzika, then CI with the so and so, whereas 1, 4, 6, and 7 submits that the interim appraise that allowed 1 week's time to obtain instructions and to place the same before the court stop. However, MSZE Nongari 1 to 3 pays for 2 weeks for the time to file affidavit stop. It's a matter after 2 weeks. Yes.
The interim order may kindly be continued.
Interim order continues like this.
Obliged, Your Lordship.
12.
For 3 weeks time to obtain instruction.
Amount sanctioned since 8 August 23, but the money is not there.
It's not been paid. I'm paying for 3 weeks time. Lordship.
I'll be making 2 weeks, Lordship. After 3 weeks, again, they will ask
3 weeks, you can't take out the money.
That's why, Lordship, make it 2 weeks.
Yes, that's paid for affidavit.
Must.
Hearing, supplementary list item number 7.
Yes. There's not a partner matter, correct?
Yes.
Yes, Lord.
Part.
No, there's not partner.
I have concluded my argument. Petitioner has argued.
No,
then
I don't remember anything.
So we will refresh Lord, the entire argument. Very short issue.
See, Mr. Arpit, there's a two partner matters in the main list.
Okay. All right, my Lord.
Item 13.
Yes. Yes, where's Mr. D?
Item 13, main list.
Partner matters. By practice and by rule, partner matters should come first. So always indicated partner is. Where's Mr. Sen?
Please, Lordship.
No, he has to come with some instructions.
Should be instead of
Certain development.
we have filed an affidavit in opposition. Bringing on record certain developments.
That's a long affidavit, but you're not supposed to file a
There was no
affidavit
order
to
also.
reply to the revision. You're supposed to bring some developments on record by your affidavit.
My lord, I have annexed those orders. Now, what happened, Lordship?
Then at least yes.
If I can, my lord, point out the timeline. After this transfer application was filed before this court, my lord, what happened? This honorable court, if I take my lot to the order passed by this honorable court, they sought for some kind of restraint order. Court did not pass. Only order passed by this honorable court, my lord, while issuing notice, that the further status quo with regard to the further proceeding between the parties before the trial court will be maintained. Injunction was never extended, your lordship. Now, my lord, what happened? In the meantime, my lord, the election of the pastorate committee was due. So, my lord, the fresh election was held and the new committee took over. Now, anticipating this and fully conscious that there is no injunction, my lord, they have filed 2 title suits. Though notice was issued, my lord, no step was taken for issuance of notice. Ultimately, both these title suits, my lord, with similar prayer. There also they have made a prayer, the similar prayer as they made in this present suit, your lordship, that he is the, my lord, pastorate in charge, duly elected, duly appointed, he shall not be disturbed. This prayer was also there. Now, subsequently, my lord, for the reason I don't know, your lordship, he filed an application for withdrawal with liberty to file afresh. But since no notice was issued, the courts took a stand that without issuing notice, we cannot give you liberty. Then ultimately, my lord, he had withdrawn the case, the similar prayer, without any seeking any liberty from the court. Now, that results in abandonment of the claim. Now, my lord, lordship will appreciate one thing here, my lord. I have come across the decision. Now, this is otherwise looks a simple transfer petition. Now, my lord, if your lordship look into the timeline, when this suit was filed, my lord, present suit, this suit was filed on 23rd November 2023. An ex parte injunction was issued. Thereafter, my lord, on receipt of notice, I entered appearance on 5th December 2023. And immediately I filed 2 applications, my lord. Both were registered as missed case. One application I filed under section 21 of the CPC, questioning the maintainability. Another application I filed, my lord, under order 39 rule 4 for discharging the injunction on the ground, these court do not, one of the ground that these court do not have the jurisdiction. Now there they have participated. Missed case was registered. Court has taken up this issue for adjudication and fixed 7 December, my lord, for filing of show cause and hearing. Now, without even reporting before the court, my lord, they came preempting, my lord. My humble submission will be, well, this is a gross abuse of the process of the court. Instead of, my lord, participating in the proceeding, he filed, my lord, present transfer applications, and by evening he produced a copy that the further proceeding in the case has been stayed. So, this honorable court, the injunction application, my lord, injunction order which was extended till 7/12 was not further extended. Even otherwise in law, my lord, the moment the plaintiff admitted before this court that the assistant to district judge, deputy commissioner, do not have jurisdiction, my lord, any injunction order passed, my lord, will cease to have any legal effect. Because a court without jurisdiction cannot pass an injunction order. So that injunction order was not there. So what I am trying to show here, your lordship, this is a gross abuse of the process of the court. And my lord, there are a number of decisions I have come across, but these are mostly of High Court, my lord. These kind of issues has never gone to the Supreme Court. All the cases, my lord, honorable High Courts, different High Courts are holding that this is purely a discretion of the court, where the similar issue is pending before the trial.
The suit abandoned.
Abandoned.
Nothing left to transfer.
Lordship.
I submit, Lordship, if my senior is.
Let him finish. Very interesting point.
Very interesting.
Yeah.
And now there is one more title suit is there. After the election, initially he tried to halt the election by filing 2 suits, including a declaration, my lord, similar declaration which he has made in the present suit, that he should be declared the rightful presbyter in charge. That prayer was also there. Now those suits were withdrawn. After the election was held, new committee took over charge, my lord, on 31st March 2024. New presbyter in charge has been appointed. Now he filed another suit, which is now pending, my lord, before the assistant to, now he has gone to assistant to district judge. Now that case we have received notice, court has not passed any injunction till date. And that case we have already filed our written statement, and as well as shocks. So that matter is also pending. So my lord, what is my endeavor to show before your lordship? This is an abuse of the process of the court.
So the transfer of this suit, that means this 2070 infructuous.
Infructuous, and in any case, my lord, if anything at all, my lord, he should go back there. Proceeding has been drawn up, 2 miscase has been registered, and Lord will see his prayer. These will lead to absurdity. His prayer is, I'll take my lord, his prayer is the suit be transferred to the court of Munsif, along with the miscases. Now, what are these miscases? Now, lordship will appreciate one thing, my lord is exercising, my lord, the original jurisdiction, civil jurisdiction of this court. It's not a read petition, my lord. Now, miscases, there are 2 miscases filed by me, 2 miscases filed by the other defendants. Both we are questioning the jurisdiction. Now, proceeding has been drawn up. Other is for discharge of the injunction order. That is also on the ground of lack of jurisdiction. Now, both these proceedings are pending before the trial. Now, suppose, my lord, now transfer this case. Now, what will be the fate of these 2 cases? These will be neutralized. Now, will you, my lord, do that? Because I have already taken up a defense before the court. Court has already framed an issue, my lord, and taken up the matter.
Yes.
Let me submit, lordship.
Yes.
Now your lordship will see, my lord. I have not completed. Let me complete.
Yes, yes.
Now your lordship, the issues your lordship. Now how many, my lord? Now before the assistant to district judge, same issue is pending. That I am the rightful presbyterian in charge. So I should be allowed to discharge my function without any hindrance from the pastoral committee. This is one of the prayer. Now how many court will take up this issue? Now before the Munsif, the present case, my lord, assistant to deputy commissioner.
I brought on the record the fresh suits. Is it done only affidavit?
Affidavit, I have the certificate copies. All the certificate copies.
So, but that's what you're supposed to do. Last time to do developments that you want to bring on record. I don't want an affidavit against the submission.
My lord, what I have annexed your lordship.
In this revision petition. It's just to know what are the parallel proceedings that are going on before the trial court.
Lordship, I have annexed both the order. If I can read, my lord. Annexure 1. Annexure 1.
If required, I can also place the plain. What if I may just submit, lordship?
But if you're fooling around with,
if I may just
lordship, you can find my lord, annexure 1. Just let me finish.
Annexure 1, yes.
Annexure 1, my
This is as in the commissioner.
5/12/23.
Yes.
Now, my lord, case record put up to the petitioner present through learned counsel, opposite party number 2 present through his counsel, such and such, opposite party number present through such and such. Petitioner has supplied the copies of opposite party number 1, the affidavit. Opposite parties have sought time. The ex parte relief is granted on the last date, extended till next date below. Release the matter on 7/12/23 for appearance of parties, filing show cause, and hearing affidavit. This is with regard to my miscases, right, your lordship. So he participated. Show cause and hearing it was fixed. Next, your lordship, the withdrawal of the suit. Now this is withdrawal of the suit.
It's not withdrawal.
This is
No, my lord, I have the copy.
They have filed civil revision. And that this court, the status quo.
My lord, court is, my lord, I'll come to that.
If I may submit, lordship, because
my lord, this is the withdrawal order, you know. These are all
He
certificates.
would do this suit.
No.
My lord, withdrawal, my lord, I have mentioned, my lord, there were 2 types.
These orders are passed in the Mr. case.
Lordship?
They passed in this cases, these orders.
Yes, in the miscases, these orders were passed. So, my lord, instead of reporting, my lord, on 7/12, he filed this case. And even thereafter, my lord, what happened? He filed 2 more suits. Similar relief, plus tried to halt the election. Court did not pass any order. Ultimately, both the cases were withdrawn, your lordships, without any liberty to file afresh. Now, my lord, those certificate copies are here, your lordship.
If I may submit, Lordship, if I may just clarify the confusion which my learned senior is trying to create. Lordship, a resolution was, I was the presbyter in charge. I still am the presbyter in charge because my appointment is made by the diocese, not by the committee here. Be that as it may, Lordship, the committee here, for the reasons best known to them, took certain steps against me as well as the bishop and the entire congregation of the church and passed certain resolutions apparently illegal as per their own constitution. Being aggrieved with that, one of the resolutions were passed is that to de-recognize me as the presbyter in charge and to kick me out of the parsonage. Being aggrieved, Lordship, we have
You went to the Municip's court.
Yes, we went to the this by way of 2070 TS number 27T, which is the subject matter of this revision. An order was passed on 24th of November, Lordship, not to interfere with my discharge of duties as the presbyter in charge and not to evict me from the parsonage. Other prayers were left open, Lordship. Ex parte order was passed. Now, Lordship, thereafter, 4 miscellaneous applications were filed, Lordship. 2 by Sir Sen and 2 by the other defendant.
Who's the defendant?
Number 2, Lordship, she is the former secretary, or that secretary at that point of time. 1 by the committee separately, 1 by the secretary separately. 2 sets of miscellaneous applications were filed. 1 under section 21, objecting to the jurisdiction of the court, and 1 for under ordinance 39 rule 4 for modification or vacation of the.
So this miss case number 170 is order 39 rule 4.
No, this 117 is my order 39 rule 1 and 2 application.
Oh, sorry, yes.
Yes. So this was passed, Lordship, ex parte. Against this, they have filed a miss case under order 39 rule 4 for vacating this order and for modification. In the meantime, they have also filed 2 other miscellaneous applications under section 21 of CPC on the ground that the court of the Assistant Deputy Commissioner did not have jurisdiction over the matter because the cause of action arose in the normal area, which is the European ward of Shillong. Thereafter, Lordship, the matter was fixed for hearing on 7th of December before the trial court. On the same day, Lordship, in the morning of 7th of December 2023, this honorable court was pleased to pass the order.
That means you concealed before this court then that the matter was fixed on that day.
Absolutely not, Lordship. Lordship may kindly come to the order passed by this honorable court of 7th December.
Yes, let's see.
That order is very clear, Lordship. December, the first order.
Yes.
If I may just quickly read, Lordship. Heard Mr. F. Learned Counsel, the petitioner who has submitted that this petition is filed before this court seeking exercise of powers of this court under Provision of Rule 1B of the Administrative Justice and Police in the Khasi and Jaiti Rules 1937, analogous to Section 24 of the CPC. The submission of the Learned Counsel is that title suit was preferred before the court of the Learned Assistant to Deputy Commissioner at Shillong, who has taken cognizance of the same in TS number 27T of 2023. The Learned Trial Court on an application filed by the petitioner herein under Order 39 Rule 1 and 2 CPC has passed an order dated 24/11/2023 in Miss Case number 117T of 23, pending before the Learned Court of the Learned Assistant to Deputy Commissioner at Shillong, inter alia restraining the opposite party respondents herein to interfere with the petitioner's functions as presbyter in charge of the Shillong pastorate. The Learned Counsel has further submitted that the respondents herein has also preferred an application under Section 21 CPC, objecting to the jurisdiction of the trial court to take up the matter between the parties, such application being registered as Miss Case number so and so. Under this circumstance, the petition is impressed upon this court that in the event an order is passed ex parte as far as Miss Case 127T of 23 is concerned, the petitioner will be deprived primarily of the advantage of the injunction order already passed. In such eventuality, the petitioner has accordingly approached this court with an instant petition with the prayer that the said title suit may be transferred to a court of competent jurisdiction. The Learned Counsel further prays that notice may be allowed to be issued to the respondents. In the meantime, an order of status quo may be passed to restrain the parties or the trial court for that matter from disturbing the present position of the respective parties. On consideration made, the prayer of the Learned Counsel is allowed, inasmuch as the petition is directed to take steps for issuance of notice upon the respondents. In the meantime, as prayed for, status quo is hereby directed to be maintained as far as the proceedings of the case between the parties before the trial court are concerned. So I have not concealed anything.
No, but then the other 2 suits that you filed?
Those were not filed at that point of time. So I am coming to that. So this was passed on 7th.
So what do you file a fresh suit?
Now, this was passed on 7th
So
December.
which suit do you withdraw?
I'll just come to that. So this order was passed on 7th December. Now, thereafter, in the month of March 2024, the committee came up with a draft election notice. Nothing to do with my functioning as the presbyter in charge. Against that, I filed a suit which was withdrawn. Why
you
was
withdrew it?
Lordship?
Why do you withdraw
Because
it?
in the meantime, they completed the election.
Okay.
So that no longer survived, Lordship, the draft notification and all. Thereafter, Lordship, once the election results were declared and certain new members have come as the current committee, I have filed a fresh suit before the court that is still pending.
Challenging the constitution.
Challenging the fresh election result. Now, there no injunction has been passed because they had filed a caveat. So now their caveat has been discharged, show cause has been filed, that matter is fixed for hearing in the coming days. That has nothing to do with this suit.
Okay.
Here, my suit is that I am against the resolution passed by the committee.
No, see, the observation of this court, where's that one? Yes, of this court that.
And my further submission is on 7th, 12th.
See, if an injunction was passed by the Court of Appellate Deputy Commissioner, now you're trying to transfer the suit to the Court of Municipal, correct? Now you are now paragraph 4 observed by this court. The other counsels for submitted respondents also prefer application of section 21. Okay, fine. Under such circumstances, the impress upon this court, then when orders pass ex parte, as far as miscase number 1 to 7 is concerned, the petition be deprived from the advantage injunction order already passed. In such an eventuality, the petitioner accordingly approach this court this instant petition of prayer said title suit transfer to court completion. Now you can't seek to carry that that order also. If whatever order may be passed by this court or transfer, like okay, fine, status quo on today, injunction matter be heard afresh. Yeah, you acceptable to that?
At this stage, what I am praying, Lordship, is that
now Mr. Sen trying to say that your transfer petition is become redundant in view of the fresh suit that you filed.
No. My fresh suit has nothing to do with this suit, Lordship.
Now, if you already out as presbyter in charge and it's dependent on the committee that's been reconstituted, has anyone taken your place now?
No, Lordship.
Lordship,
We have a fresh presbyter in charge.
Lordship, the presbyter in charge, I'm sure the defendant.
Now the thing is that now we're not going to go deep into the facts of who appointed the judge. The only fact is that you were presbyter in charge.
I still am presbyter in charge.
That is your contention.
Lordship, yes.
Correct.
Yes.
So that issue still survives, Mr. Sen. That means with regard to
because presbyter in charge has nothing to do with the committee, my lord. Presbyter in charge is appointed by from Delhi, not by the committee.
Lordship.
They have no say on
I cannot get. Now, but this presbyter in charge, my lord, so far he is concerned, he was derecognized, my lord, way back in September 2023. Now he went, filed a series of FIR, he went to police, he brought police, he tried level best, my lord, to remain there. Ultimately, in the month of November, your lordship, 23rd November, he instituted a suit saying that I am the rightful presbyter in charge. Now, 24th court had issued an interim injunction.
Yes.
Now, 5th, I entered appearance. Immediately, I raised the question of maintainability as well as for discharging this.
That's why you filed for transfer.
On the ground that court lacked jurisdiction. And if there is an inherent lack of jurisdiction, which now he is admitting before this court, what are the consequences? Any order passed by that court which is not competent will be of no consequences.
What we do, but then it appears that's a different cause of action.
No, I'm
coming to the new suit.
Absolutely, I'm coming. Absolutely. I'm just coming. Because what I'm trying to show your lordships, now what happened, what is his prayer in the suit? If I can take my lord to the revision petition.
In this suit, which is being transferred.
Yes, your lordship. This is, they have annexed.
My prayer is at page 27, 26, I'm sorry, 51, lordship, 51 of the revision. 51 of the revision.
You have the prayer.
51.
Now that Shillong Pastorate Committee, new elections been held.
Yes, we have taken over charge on 31st
Now
March.
you're claiming to be ex officio president again. By the suit.
In the fresh suit? No, Lordship.
No, see a declaration here.
Lordship.
That the president of the duly appointed president in charge of Shillong Pastoral as well ex officio president of the Shillong Pastoral Committee.
No, what, if I may just clarify, this Shillong Pastorate Committee's Lordship, basically, the appointment is made by the constitutions of two parts. It is the committee, Lordship, which are the members from the local level, are appointed through election approved by the diocese. And the presbyter in charge, Lordship, is not.
How are you appointed then? What?
I have appointed.
How are you appointed?
By the diocese. By the diocese.
Where does he derive his power from?
By the diocese.
Lordship, that you will have to, Lordship, go into
And
the
kindly,
history of it. Now, my Lord, this man, he lost total confidence of the congregations. Now, my Lord, what is called, my Lord, pastorates. Now, the pastorates, my Lord, under the constitution, my Lord, which is also followed, along with the convention, my Lord, they have called for a full house general body meeting, you know, special general meeting. In the special general meeting, my Lord, we have de-recognized him, which was participated by almost all the worshippers. And there was an unanimous resolution that this man should go. We do not accept him. And we have sent these copies to the higher ups. Now, it is up to them, my Lord, whether they will act or not. This man ceased to function as a presbyter in charge. That happened, my Lord.
No, it comes to this one. If he was appointed by diocese, now whether you have the power to remove.
That is the exact subject matter. Kindly see page
Lordship,
221.
Now, my Lord, entire thing, my Lord, exercise was taken by a bishop, whose name is, my Lord, Michael Herons. Now, these are the Michael Herons. Now, what are the, my Lord, the issue, my Lord, the core issue here? Michael Herons, at one point of time, my Lord, he wanted to convert. This is a heritage site. He wanted to convert the leasehold rights of this church, my Lord, into a commercial one. This has resulted into huge, my Lord, commotion in the pastorate. They thereafter, my Lord, called for a meeting. And after detailed deliberation that this Michael Herons is working against the interest of the church.
The bishop,
my Lord, who is the present bishop. My Lord, we passed a resolution, my Lord, de-recognizing both the presbyter in charge, and he was hand in glove with the bishop and Michael Herons. And since then, my Lord, they have not played any role. Now, this man, even if he issues a letter, my Lord, this is of no consequence.
No, Mr. Sir, what this point stands fine. If you're not sure about, you know, the where source of power comes from, who appoints.
I can
kindly see the General Clauses Act. Now, the thing is that if he's appointed by another authority, can another authority, or maybe the committee, special committee of the pastorate, whatever, remove him?
My humble submission can. Lordship can, because
that has to be taken.
No, that has to be
then the case made out for transfer, then be transferred to court competent jurisdiction, and then let them thrash it out there.
No,
it's not a question of killing the bird now only.
What I am saying, Your Lordship, one thing what I will try to show, my Lord, similar prayer. I will just read out the prayers. Similar prayers, my Lord, in this suit, which is before Your Lordships.
Made in
two suits which were withdrawn, similar prayer, and now one more fresh suit along with other prayer.
How many suits are pending now?
Pending before assistant to district
One
judge.
in connection with the new election.
And not in the new election, man. That's wrong. That I'll point out. That similar prayer was there also in that suit. Now, my Lord, here I will show Your Lordships. There are a number of decisions of the various high courts, my Lord, which say, my Lord, so far the power of transfer is concerned under 24. This is purely a discretionary power. When the issue has been taken up by the trial
power, but the thing is that, Mr. Sen, that it's apparent itself that the court which had taken up the matter initially lacked jurisdiction. So then the only thing is transfer it.
No.
Lordship,
I'll just come back, man, if I can finish, my Lord. No, if Your Lordship go by CPC, my Lord, Order 10, Rule 7. Order
10 is for Supreme
Order 7, Rule 10.
Oh, sorry, Section 10.
Order 7, Rule 10. Now, what do you say, my Lord? If there is inherent lack of jurisdiction, suit is to be returned. And here is the case Lordship will appreciate. As early as on 5th December, I have filed an application.
So you filed a 711 application for
21 will lead to, my Lord, not 711. That he could have filed. Now, 21 will lead to returning of the plaintiff if there is no jurisdiction. So, matter was registered as a missed case. This issue was taken up by this trial court on 5th. They were allowed time to file their shock.
I understand. See, what they're doing is a tactical kind of, exercise to preempt further orders whereby his claim would be rejected. Right? He has come before this court and said transfer the suit to a court of competent jurisdiction while safeguarding the injunction that is granted to him. That means to his function as a presbyter in charge. That is his main grievance.
That is the end.
Then the second grievance, he says, because like he's agreed with the reconstitution of the pastorate committee. So the way elections were held. So that is a different cause of action which has arisen, for which he's filed afresh.
I'll just read out the prayer, man. This is before me, man. I'll just read out. In this present case, my lord, what is this prayer, your lordship? Declaration that the plaintiff is the
prayer and the suit.
Page 51.
Page 51, yes.
My lord, declaration that the plaintiff is the duly appointed presbyter in charge of the Shillong Pastorate, as well as the ex officio president of the Shillong Pastorate Committee, along with the right, interest, role, duties, responsibilities arising. I mean, what he says in the title suit, my lord, 1, which was withdrawn. In the view of the above stated facts,
which was withdrawn?
My lord, certified copy, my lord.
I don't have it here. That is why Mr. Sen, last time when we hear this, when he pleads the submissions, that is the court. Okay, fine. Okay, fine. Please those documents and court.
Both this suit, I will please.
Why is it placed then? Why do you annex on it ordered it 5?
I'll just place it. Today is the
Lordship, I'll just take a
What do you
minute.
want to say?
I'll just take a minute, my lord.
Who are you?
I'm the appointing authority. I'm the appointing authority of the petitioner and the diocese.
You're still in office.
I'm always in office. Diocese. I'm the diocese. My lord, I don't have a horse in this particular race. But
You don't have a horse
in this particular
you're a
race, my lord.
jockey.
But being pleaded in the proceedings, being the appointing authority, if Lordship allows me to make one or two small observations, my lord. Lordship, my first very respectful submission is that this honorable court, exercising jurisdiction under section 24 of the CPC, is being unnecessarily dragged into the facts.
Yeah, correct.
Is being unnecessarily
But
dragged
do you understand the whole picture?
Yes,
instead of passing an order, only
Yes,
what's the official
yes, ma'am.
procedure. That's why you wanted to see what are the other,
the aspects of it. And, understood, my lord, appreciate that completely. But if Lordship allows me to place this particular judgment, there is only one aspect under 24 that this honorable court will have to kindly look at. Now, if I'm allowed to read para 12, my lord, of this 2010 Supreme Court judgment, para 12.
So you're supporting the petitioner's case?
My lord, I'm supporting the cause of justice because unnecessary time is being taken of this honorable court.
Yes.
Para 12 clarifies, my lord. Section para 12, para 12. Section 25 of the code itself makes it clear that if any application is made for transfer after notice to the parties, if the court is satisfied that an order of transfer is expedient for the ends of justice, necessary direction may be issued for transfer of any suit, appeal, or other proceedings from a high court or other civil court in one state to another high court or other civil court in any other state. In order to maintain fair trial, this court can exercise this power and transfer the proceedings to an appropriate court. The mere convenience of the parties may not be enough for the exercise of power, but it must also be shown that trial in the chosen forum will result in denial of justice. Further illustrations it goes on. Point is very simple, my lord. If it is obvious, and I would submit it is very obvious here, that continuance of the proceedings in the existing forum at some point.
You are representing the
Number 3.
pro forma.
Number 3.
Okay.
So the point is, my lord, that if it is obvious, and it is obvious in this case, the continuance of proceedings before this present forum will result in a situation that today, tomorrow, day after, his suit will be dismissed. That means whatever justice he's seeking, for whatever reason, will be denied. Then that is enough reason for this honorable court to exercise power under section 24. Various points have been raised. I am sure that there is merit in those points. But with respect, my lord,
merit points the question of getting a clear picture.
Yes, my lord, because for example, my lord, the contention that
when it comes down again is discretionary power. So that is it.
Quite possible, my lord, quite possible. But for example, my lord, the contentious issue that has been that is being argued, that one is saying that it's the same cause of action, the other side is saying
that's not material for consideration. You mean?
It is not.
See, we're trying to break it down as follows. To what is the prayer now? And the thing is that because Mr. Sen has raised certain, issues with regard to whether he's come to this court with clean hands at all. You see, that's the thing. That's what disturbs the mind of the court, is that if the matter is fixed on the 7th of December,
Yes, my lord.
for consideration,
Yes, my lord.
he comes to this court and gets an order,
Yes, my lord.
which gives a status quo. It clears the whole pitch. That's what's happened in this case. So that is why Mr. Singh is trying to impress on the court that the conduct of the petitioner, like doing, like taking any measure to hold on.
Understood.
That's the thing. Now, by making a submission also that the benefit of injunctions that have been given will not be carried over to the transferee court. See, those are the things which should not be considered at all.
Absolutely.
But the conduct of the petitioner,
naturally,
I'm saying tactical advocacy, what I do not know what the practice here, but there is a certain element of of abuse of the process of court, that is why the court is examining this, and whether if that is correct, and whether in the second suit we're just seeing whether that is it's a continuation of that whatever he's doing, like filing two other separate suits, one withdrawn. The very fact the suit's withdrawn, filed again, these suspicions. Again, you file another suit. If the cause of action again is on the same ground of which he's seeking a transfer, that if this fails, then so those kind of things. That is why this court is examining. As a pure matter of transfer, is a 5-minute job.
Absolutely.
That's all.
Absolutely, my lord.
As per your judgment. That's it.
Yes.
If we see that's fine, the court committee, like, you'll not get relief here. It lacks inherent jurisdiction. It takes 2 seconds to.
Yes, my lord.
For the conduct of the petitioner.
Absolutely.
Absolutely. Playing hide and seek.
Absolutely.
That's the thing.
Absolutely. If lordship is intended to examine the cleanliness of the petitioner's hands, my lord, lordship is very well entitled to do that. But I was
just to satisfy the court. That's why I asked Mr. Sen. Yes, produce. He has made submission that this is happening. So let me see those orders. But instead, it's an affidavit based, and it's only one.
All the certificate copies we have.
No, only thing you've announced only the 5 and 7, which is only submitted.
I'll file in the court.
That's the only thing.
My lord, what is disturbing here, my lord, the similar prayer in so many courts, your lord. That's
what I just want to see. And so then maybe we can, correct his, take a corrective course, with regard to how he, conducts the matters.
I'll place it, my lord.
We understand. Otherwise, it's a matter, it's a 5 minutes.
I understand, my lord.
It just takes 5 minutes to dictate the order. But we have to make observations with
If I
regard
may-
to the manner in which you have, you have pursued your
If I
remedy.
may submit, lordship, I may be allowed to give a small compilation along with the.
You want to withdraw?
No, I'll file a compilation of all the suits.
No
and
need
dates.
compilation.
And
these 2 suits, my lord, I'll place with you.
We'll after 1 week, we'll dispose it of. We understand, except general submission also, it's confined, that examination is confined to that aspect only. But the only thing is that the way you've gone about it, that's the
Lordship,
thing.
what has on 7th, lordship, it was informed very well that we are filing a revision petition. Perhaps Leonard Senior was not aware because he was very sure that the suit will get dismissed. And in the evening, when we got the order from this court,
Be returned, my lord. I was anticipating the suit would be returned. That's what the court says.
Yes.
My only option here is to return the plea.
So that is why he was holding on to anything he got.
In the
That's why.
evening, when he got the status quo.
After that, what is his conduct? My lord? Same prayer. I'll place it before you. Same prayer making in so many courts. Trying his luck.
And what the poor people in the pastorate being made to suffer for the fight of the you all. Yes.
You place it.
Yes, Mr. Sense admits that due to inadvertence, the other required materials cannot be placed for the court today. Please for allowed tedious time to produce the separate copies just on after 1 week. Just give the copies, that's all.
Yes, my lord. Both the 2 suits.
It's just that we might make a small observation, that's all. But then,
Lordship.
Obliged.
14.
We'll start with the affidavit filed by respondent number 2, my lord. Paragraph number 9.
last time this matter was heard was on 11 July 24, that's 2 months ago.
My lord.
Yes.
My lord,
You had argued on the, on the impure notification taking your right, the list angle Article 25(2), Article 26(b), Article 29, then, yes.
Now, my lord, I'll start with affidavit, my lord, filed by respondent number 2.
Yes.
My lord will come to page number 8.
Yes.
Paragraph 9, my lord. I'll just read out, my lord.
Which?
Page number 8, paragraph 9. This is the affidavit in opposition filed by respondent number 2, my lord.
Sorry. Wrong affidavit. Yes.
Paragraph 9, my lord. This paragraph shows the stand of the Jaintia Hills Autonomous District Council as regard to this case. I'll just read out, my lord, that with regard to the averments and statement made in paragraph 10, 11, 12, and 13 of the writ petition, the deponent denies the same and states that the notification dated 19/4/2023 has been issued by following due process of law as laid down in section 4 of the Act of 2015. It is reiterated herein that the customary practice in existence and prevailing in Rimba Ilaka has never been violated, in as much as in cases or situations where a doloi who has been elected belonging to a Niyamtre denomination, it is the doloi who shall perform the religious ceremony and rituals. But in cases or situations where a doloi has been elected belonging to Christian denomination, it shall be a lingdo who shall perform the religious and ritual ceremony, so as the customary practice is not disturbed, discontinued, or broken down. As such, in view thereof, the customary practices prevailing with regard to the performance of religious ceremonies and rituals in the Ilaka is still enforced and not disturbed or discontinued. So, this is the stand of the JHDC, my lord, that whenever a doloi is elected from Niyam Khasi faith, my lord, then it will be the doloi who will perform the rituals. But in cases where the doloi is elected from Christian denomination, my lord, then it has to be performed by the lingdo. That is their stand. Now, I'll come to my submissions.
Suppose the lingdo as a Christian?
Yes, my lord, that is one aspect that they have not clarified on that point.
Right.
Now, my lord, I will come to my submissions, my lord. Now, my lord, the drafting committee constituted by the Constituent Assembly, my lord, while drafting the constitution, keeping in mind the long-standing history, my lord, and civilization, they have entrusted upon the state, my lord, a duty to protect, safeguard, and enrich, my lord, the rich culture, traditions, and as well as, my lord, the heritage of this land. Now, therefore, my lord, they have incorporated Article 25 till 29, my lord, in the Constitution. Now, Article 25, my lord, it provided the citizen with a right to freely profess, practice, and propagate their religion. Therefore, my lord will see a Christian person, he has the right to freely profess, practice, propagate his religion, that is Christianity. Similarly, my lord, likewise, the people from other faith as well, my lord, they have similar right to profess, practice, propagate their religion. But, my lord, the custom and traditions of one religion, my lord, it cannot interfere with the custom and religion of other faith, my lord. Now, my lord, as far as the rights of our religious practices of one religion, the rights of our religious practices of one religion, my lord, it can be exercised by a person who belongs to that particular religion. Now, this right, my lord, it cannot be extended to other faith. My lord, I'll give you an example also, my lord. Now, my lord, as far as Christian is concerned, they have various religious rites and rituals in terms of marriage ceremonies, burial rites, or baptism. They have their own religious practices. Now, my lord, a person belonging to a Christian faith, my lord, of that particular denomination, he will have the right over these religious practices of a Christian. Now, my lord, a non-Christian who does not belong to a Christian faith, my lord, of that particular denomination, he will not have the right he will not have the right to assert claim over the religious practices of Christian. He cannot come and say, no, I want to be the pastor, even though he belongs to some other faith, or I want to do these rituals. Now, these, my lord, these are restrictions, my lord, which are there not to take away somebody's rights, but to ensure the rights, my lord, which is already there in our Article 25, 26. Likewise, my lord, in our instant case, my lord, the doloi, my lord, the person who will be elected as a doloi, he has to be from the Niyamkari Niyamkhasi faith. And my lord, this restriction is not to take away somebody's right, but to, my lord, ensure the rights which is already there in Article 25, 26. And therefore, my lord, I have already, my lord, in earlier occasions, I have already relied to one judgment, my lord, that I will come into my later submissions. Now, coming to the custom, my lord has asked a very pertinent question, whether this court will have to determine custom. Now, my lord, as far as custom is concerned, my lord, custom does not always means, my lord, that it has to be related to a religion or religious practice. There can be custom, my lord, which may not have to do anything with the religion or religious practices. My lord, in some places, in a particular day of every year, my lord, there are people who from the village who comes together and do fishing on that particular day in a particular river. Now this has been followed for so long period. Now it has taken the shape of a custom, but it has got nothing to do with religion or religious practices. And therefore, my lord, it is not necessary that every, my lord, religious practices to get, my lord, the protections of law has to be a custom. My lord, here we are concerned only about religious practices, and my lord, therefore, it is not necessary that the court has to come into any conclusions as regard to any religious practice, whether it is a custom or not. Now, my lord, if we see the constitutions, my lord, Article 25, 26, it gives guarantee, my lord, as regard to the religion. 25, 26, 29, if we go through, my lord, it gives guarantee of their religion, religious practices, their culture, traditions. It nowhere, my lord, in these articles, it has been stated anywhere that these religious practices has to be custom so that it will come under the protection of Article 25, 26, 29. It is not the requirement. What is required is, my lord, it has to be a religious practices which has been guaranteed by Article 25, 26, 29. It is not necessary to be a custom to come under the protections of Article 25, 26, 29. Now, my lord, the traditional and religious institutions of Doloi, my lord, it is interconnected, my lord, with various activities, religious, secular activities that may be administrative in nature. Now, my lord, it is not only necessary that only the institutions of Doloiship has to be protected. It is equally, my lord, important that all the activities which are associated, whether religious, administrative, secular, my lord, all these activities has to be protected equally, my lord. Why? It is because, my lord, removal of one will amount to removal of the other, my lord. If we remove,
say that.
Yes, I'm
if
saying.
you see the duties are secular and secular duties, and you have religious duties.
I'll come to it, my lord. My lord, why I'm saying the removal of one will lead to removal of the other. Now, my lord, Doloi, my lord, as my lord knows, Doloi is traditional, customary, religious head of that particular area. Now, my lord, if we remove the religious practices from Doloi, then, my lord, the religion itself will fall. Once we remove religious practices, the religion itself will fall because, my lord, this is the essential part of that religion. And therefore, my lord, the judgment which I have relied, my lord, earlier, if my lord will come to the judgment, that is the by the Honorable Supreme Court. That is there, my lord, with the, your lordship. Commissioner of Police versus Acharya Jagdish Paranandan. I have given on the last occasion, my lord. It should be there in the report.
Yes, okay.
If my lord will if my lord will come to paragraph 9, page number 782.
Paragraph?
Paragraph 9, page number 782, my lord. 2004, volume 12, SCC 770. Now, my lord.
Yes.
Only the essential part, my lord, which I would like to read. Paragraph 9, last two paragraph, my lord. What is meant by an essential part or practice of a religion is now the matter of elucidation. Essential part of a religion means the core belief upon which a religion is founded. Essential practice means those practices that are fundamental to follow a religious belief. It is upon the cornerstone of essential parts or practice that the superstructure of a religion is built, without which a religion will be no religion. Test to determine whether a part or practice is essential to a religion is to find out whether the nature of the religion will be changed without that part or practice. If the taking away of that part or practice could result in a fundamental change in the character of that religion or in itself belief, then such part could be treated as an essential or integral part. There cannot be additions or subtractions to such part because it is the very essence of that religion, and alterations will change its fundamental character. It is such permanent essential part which are protected by the Constitution. Now, as my lord knows, the post of Doloi, my lord, this is the traditional, customary, religious head of that particular ilaka. Like in matters of Christian faith, my lord, there is father, pastor. Now, if we remove father or pastor from his religious duties, what will remain there? The religion itself will fall. Now, this Doloi, my lord, he is the traditional religious head of that particular ilaka. If we divest the power, if we divest the religious activities from the Doloi, my lord, it will amount to removing the religion itself. And therefore, these are inseparable. It cannot be separated. The activities which is religious, my lord, as well as secular, my lord, it cannot be separated from one another. Now, if, my lord, if we allow, my lord, that a lindo should perform the religious duties, my lord, it will...
Majority is a majority judgment.
Yes, my lord.
This is why? Because this is for a judge bench.
Now, if we allow, it will violate the rights which has been guaranteed under Article 25, 26.
Well, let's see the majority view then. Because there's a dissenting view here also.
This part, my lord, which I read is not dissenting, my lord.
Okay.
Now, if, my lord, if the lingo is allowed, my lord, to perform these religious practices, it will directly hit Article 25, 26. Because this is the guarantee of the constitutions under Article 25, 26, that they will have the right to freely profess, practice, propagate their religion. And as per the judgment of the Honorable Supreme Court also, my lord, these are essential part of that particular religion to exist. Once we remove this, my lord, the religion itself will fall. If my lord, we see
Yes.
The post of dollar, my lord, it has two parts. One is religious activities, the other is secular activities, that is administrative in nature in some cases. Now, the religious part, this is the soul of these institutions. And the religious part is the soul of these institutions, and the secular activities, my lord, that can be compared with the body. If we remove the soul, my lord, that is religious part, the body cannot survive. Because it needs the body to survive.
And it gives in spirit.
Yes. Now, my lord, it cannot be in existence. If we remove the secular activities, my lord, that is amounting to removing the body. And then the soul cannot survive without the body.
We say if you remove secular activities.
Yes, if we remove even the secular activities, because these are very much integral, essential part.
So you say that the Dolloy's office, of course, that is known, it can be bifurcated. You can't have a Dolloy to do secular duties or administration, and you can't have a Dolloy to perform religious rites only.
Yes.
So you're saying that it is one.
It is one, integral.
It can be bifurcated.
Yes. These two, my lord, it consists the post of Dolloy, the institutions of Dolloy. One is the soul, another is the body. One cannot exist in absence of the other.
Okay.
Now, in a very lighter note, my lord, as far as our lawyers are concerned, we cannot do heart surgery in a patient because we are not equipped with the law, equipped with the knowledge. We are not having the degree. Similarly, my lord, a person from other faith, my lord, he cannot perform those rituals which is attached with the post of Dolloy.
No, that is not denied. They said fine. They don't deny. They said fine. Like if a Dolloy is elected from who's a Christian, if he cannot perform the rites, then like the practice was that then the lingdo priest will do it.
That is their stand. But
no, the thing is that okay.
My contention, my lord,
that is what they say.
That is my another point of argument, my lord, that a lawyer cannot do surgery on a patient because he is not equipped with the knowledge, he is not equipped with the expertise degree. Similarly, my lord, as far as persons belonging to other faith, he is not equipped with the knowledge to perform those rituals which is attached with the post of Dolloy.
So that is
and therefore, my lord, why I am saying, therefore, if we allow, it violates Article 2526 because Article 2526 gives guarantee, my lord, to the citizen that he will have the right to freely profess, practice, propagate his religion. What about his religion? Now, my lord, here I skipped one point, my lord. When these rights, the rights over religious practices of one religion, it cannot be extended to other religion. While saying so, my lord, I have already given the example of people belonging to Christian faith. He will have the right over religious practices of Christians. These rights, which is guaranteed under Article 2526, my lord, these are to some extent individual rights. It can be exercised in a compartment. That compartment is their religion, my lord. He cannot exercise beyond his religion. He can exercise this right being in that particular religion within the religions, within his religious practices. He cannot extend these rights to other religious faith. So, these rights, my lord, which is under Article 2526, it cannot extend to others' faith. He can enjoy these rights with it being in his own particular religion, within his religious denomination. Now, my lord, as far as, my lord, tangible cultural heritage of our country, like monuments, old temples, my lord, these are protected, my lord, under Article 49. That relates to directive principles of state policy. Now, my lord, Article 49, it says protections of monuments and places and objects of national importance.
Yes.
It says it shall be the obligations of the state to protect every monument or place or objects of artistic or historic importance to be of national importance from spoliations, disfigurement, destructions, removal, disposal, or export, as the case may be. So, as far as tangible cultural heritage is concerned, my lord, these are protected under Article 49, under Directive Principles of State Policy. Whereas the intangible cultural heritage, which relates to religious practices, traditional institutions, these are protected under Article 25 till 29. These are given to the citizen as a right, and therefore the state has a duty to protect these rights. Now, not only that the citizens are given with these rights, they are also vested with a duty under Article 51A. If my lord will see 51A,
Yes, what duty is it?
51A clause F, fundamental duties. It says it shall be the duty of every citizen of India to value and preserve the rich heritage of our composite culture. Even though these are given as a right to the citizen, citizens are also vested with the duty so that they value the other's culture. Therefore, my lord, the state is duty bound, my lord, to protect the rights which has been guaranteed by the constitutions, and if any violation, my lord, this court, my lord, under Article 226 can give necessary direction. Similarly, my lord, in one of the case before the Madras High Court, my lord, coming to these restrictions, my lord, what has happened, my lord? In this case relates to an incident where persons from Muslim community, my lord, they wanted to enter inside a temple. And there is the reference in this case, my lord, if my lord will see at paragraph, page number, I have already flag marked, my lord.
Which first flag mark?
Yes, no, my lord, second flag mark, paragraph 2, page number 4, my lord. What has happened? There are instances which has been mentioned in this case, my lord, where persons belonging to other faith, they entered inside temple premises, they ate non-vegetarian food, and then in some cases they offered namaz. The case went before the Honorable Madras High Court, and Madras High Court directed that why the case went. It is because they wanted some direction. That direction, my lord, the first flag mark. First page.
Page number 6.
No, first page, my lord. That first flag mark only. First page. And then prayer persons, next page. The writ petitions filed under Article 226 of the Constitution of India.
Where reading from?
My lord, this first page, and then my lord, the prayer person is at second page. Continuation, yes. Prayer. Now, my lord, it says, writ petitions filed under Article 226 of the Constitutions of India, praying this court to issue a writ of mandamus to direct the respondent to permit Hindus alone to the hill temple premises and its sub-temples, and consequently directing the third respondent to display board to that effect in all entrances based on the representation of the petitioners. Now, after hearing the matter, my lord, the Honorable Court, Honorable High Court, my lord, at page number, at the last flag mark, my lord, page number 54. Page number 54, paragraph number 27. Last flag.
Yes.
It gave direction For the reasons discussed above, the writ petitions is allowed with the following direction to the respondent. The respondent shall install boards indicating that non-Hindus are not allowed inside temple after Kodimaram, in the entrance of the temple near Kodimaram, and at prominent places in the temple. The respondents are directed not to allow the non-Hindus who do not believe in Hindu religion. If any non-Hindu claims to visit particular deity in the temple, then the respondent shall obtain undertaking from the said non-Hindu that he is having faith in the deity and he would follow the customs and practices of Hindu religion and also abide by the temple customs. And on such undertaking, the said non-Hindu may be allowed to visit the temple. Now, there are various cases, my lord, where such directions restricting, my lord, one community belonging to some other faith are restricted. These restrictions are not to take away their rights, my lord, but to ensure the rights which is already guaranteed by Article 25.
It's not been put to challenge.
My lord?
It's not been appealed against. Sure.
My lord, in my understanding, my lord, no.
The petitioner is Kaman Senthil Kumar. Yes.
Now, there is another judgment, my lord, this in Madras High Court, where my lord, the Madras High Court,
yes,
as regard to the temple, it has given direction to maintain, repair all these old temples, and the commission was set up. If my lord will see the last flag, here it says the respondent shall establish Malappuram World Heritage Area Management Authority to manage and safeguard all the monuments, and the same shall be notified within a period of 8 weeks from today. The respondent shall continue the Heritage Commissions consisting of 17 members within a period of 8 weeks from today, who shall act as an advisory body to the Malappuram World Heritage Area Management Authority and the government as well. Now, my lord, the next page is paragraph 4. The Heritage Commission shall identify all the structures, monuments, temples, antiques with historical archaeological importance within the state of Tamil Nadu, formulate a list with age of such monuments by categorizing them within their period group, issue appropriate notifications, render periodical advices to the state, supervise the restorations, repair works, etc., and maintain the same. My lord, this is the duty of the state, my lord, to protect these monuments, these rituals, and as far as, my lord, intangible cultural heritage is concerned, as I have already pointed out, my lord, this has been given as a right to the citizen, and also, my lord, citizens are.
But this is regarding only the preservation of
Right.
these
Yes,
structures of archaeological importance. Right.
Now, as far as our case is concerned, my lord, we are concerned about intangible cultural heritage. Now, here, my lord, there is an international convention, my lord. That is Convention for the Safeguarding of Intangible Cultural Heritage, where our country is one of the member states. This is an international convention, my lord.
UNESCO.
My lord.
UNESCO, yes. Where
Yes.
intangible?
Yeah, intangible. Now, page number 2, my lord.
See, Mr. Sultan, one thing is not that these religious rites are not performed. The only dispute here is whether, in the absence of a Dalai who professes, who's a Christian or any other faith, not indigenous Nyamtandrai, whether that religious rites get affected and the practice in Rambai Leka gets affected. Now, the only stand of the council that no, because the Lingdor does it. So only that's the only thing.
That is
So
the
regarding
only-
protection intangible, then
No, because my
it's
lord,
not a case that has been suspended, that these practices have been suspended or they have not been,
that is true, my lord. But this convention, where our country is a member state, my lord, this convention, if my lord will see at paragraph, page number 2 of this convention,
seen that.
yes,
Yes.
it says that is regarding definition. For the purpose of this convention, the intangible cultural heritage means the practice, representation, expressions, knowledge, skills, as well as the instruments, objects, artifacts, and cultural spaces associated therewith that communities, group, and in some cases, individual recognizes as part of their cultural heritage. That this intangible cultural heritage transmitted from generation to generation is constantly recreated by the communities and group in response to their environment, that interactions with nature and their history, and provides them with a sense of identity and continuity, thus promoting respect for cultural diversity and human activity. If my lord will see 2, my lord, the intangible cultural heritage as defined in paragraph 1 above is manifested inter alia in the following domain: oral traditions and expressions, including language as a vehicle of intangible cultural heritage, performing arts, social practices, rituals, and festive events. This is where we are concerned. Rituals. Now here, our country, being a signatory to this international convention, my lord, is duty bound to protect these rights. If, my lord, what the JHDC is saying, that the religious practices can be given to the dollar for its performance. That is not the religious practices of the Niyantra faith. As per the custom, my lord, this has to be performed by the doloi, who has to discharge both these religious as well as administrative duties. So, my lord, my submissions, my lord, to some extent, I'll sum up, my lord, that our state, my lord, this has completely failed, my lord, as far as the post of doloi in this ilaka is concerned. They have completely failed to protect these rights, to preserve. Whereas they are bound by the constitution, they are bound by the conventions which they have signed with the in the international arena.
What about, you not touched upon, what about the, the regulatory functions of the council and the 6th schedule, whether they are, it's incumbent upon them to do, a sort of a study, and whether, in this case, hasn't seemed, even the what do you call it, notification is very cryptic and bold. Yes. So whether that is the point to examine, whether in discharge of their, this is a constitutional authority. So whether in the charge of the constitutional functions, whether they've examined these aspects, not in this case, in other cases also. That's important also, because that is what they were constituted for. One of the main functions as a constitutional authority was to, for preservation and for regulation of, social customs, and for regulation of the offices of traditional institutions. These things are there. But anyway, that part you've not addressed, doesn't matter. Yes. You can reply after you finished.
I'm almost done, my lord. Because I have already submitted on the earlier occasion also, that to the Article 25, 26.
Yeah.
So therefore, my lord, in my understanding, my lord, the notification, my lord, that is wrong. That has not been followed as per law. And my lord, irrespective of whatever is there in the Act of 2015, the petitioners, they are entitled to the fundamental rights that is guaranteed under Article 25.
That's it.
That is.
When did you reply, Mr. Sen? You replied another day. You have some points.
Yes, I have noted.
Even last time you taken place. After 1 week, or next week. Next week is what? Next week on 19th. We'll conclude on that day. Yes. This is matter. And you have the other authorities. You kindly, provide them. Yes, a matter on 19 okay, for further hearings.
Supplementary list, item number 7.
Long, very well. It's download good for YouTube. Long, you're practicing. How long will it take? We'll give you 15 minutes to complete.
Yes, I can complete by that time.
5 minutes.
10 minutes or so I can complete.
Very good. Yes.
Your Lordship, there is a notification of 5 March 2021 where they have put 100 hectare minimum for mining this. My question to myself, whether this 100 hectare is authorized and conferred by law. The answer is very clear and simple, that under MMDR Act Section 6, there is no provision authorizing
the state
or me for fixing 100 hectare.
Now, if I remember correctly, there's a prescription for maximum area, but not for minimum area, correct?
Yeah, minimum area. Yeah, under MMDR, only maximum area, Your Lordship. Only maximum area. Minimum area is not fixed by the law. So I have based on this Supreme Court ruling, wherever it says that.
Or the master students.
Yes, sir.
The master students judgment.
Yeah. State of Meghalaya versus all the Masa Student Union, you know.
Yes.
Page 254, para 142, Your Lordship.
Page
254, 254, para 142, Your Lordship. If you permit me, I will read.
Yes. Got it.
Yes, Your Lordship. Certain legislation framed by the District Council has also been referred, namely the KHDC, Trading by Non-Tribal, Regulation 1954. The United Khasi Jantia Hills Autonomous District Council Management and Control Forest, Rule 1960. Khasi Hills Autonomous District Trading by Non-Tribal Rule 1959. All framed in exercise of the power under Para 3 of the 6th Schedule. The power to make law entrusted to Autonomous District Council under Para 3 of Schedule 6 is power to make law referable to Lease 2 and Lease 3 of the 7th Schedule. We have already noticed above that with regard to regulation and development of mineral, the Union has made declaration by Section 2 of 1957 Act, and the power of the state legislature is denoted in that respect. Logical corollary of the above principle is that power of Autonomous District Council shall also be denoted insofar as regulation and development of mineral to the extent which is covered by 1957 Act. We may refer to one Rule 4 of the United Khasi Jantia Hills Trading by Non-Tribal, which contemplate form of license and one of license referred to Rule 4 is license in Form 4 as follows. This one I will not read. Then I will jump to para 195.12, page 276. 276, Your Lordship. (195) subparagraph 12. The Union having made declaration by Section 2 of 1957 Act, taking under its control regulation and development of mineral, the power of autonomous district council to legislate on the subject shall also be denoted as that of the state legislature. I may also be allowed to refer to page 151 of the 6th schedule to the Constitution of India by Justice B.N. Pansaria.
The latest edition.
Fifth schedule. Fifth schedule.
Which edition?
Fifth schedule, Your Lordship.
No, which edition?
Or fifth edition.
What is fifth schedule? Fifth schedule. Very, very confused.
Fifth edition.
Yes.
Page 151. The last paragraph, Your Lordship. Para 12A.
1 second. Yes.
Para 12A, capital A, clause B of 6th schedule to Constitution of India empower that the President may, with respect to any act of Parliament, by notification direct that it shall not apply to an autonomous district or an autonomous region in the state of Meghalaya, or shall apply to such district or region or any part thereof, subject to such exception or modification as he may specify in the notification. No notification has been issued by the President under Para 12AB, excluding the application of Mineral and Mine and Mineral Development Regulation Act 1957 in the Hill District of Meghalaya. The government of Meghalaya made a request to the government of India in the year 2015 for issuing of presidential notification under Para 12, capital A, clause B of the 6th schedule for exempting the state of Meghalaya from certain provision of the MMDR Act 1957. The Union of India, by communication dated 12/2/2019, rejected the request of the government of India of Meghalaya for issuing of presidential notification under Para 12, capital A, clause B of the 6th schedule. Thus, MMDR Act and the Mineral Concession Rule 1960 are applicable to the tribal area. Next para, Your Lordship, Para 2. The Union of India has taken over the control, regulation, and development of coal under Section 2 of MDR Act. The power to the legislature or the power of the legislature and the autonomous district are taken away, and they have no power to legislate on mining of coal. Further, Your Lordship, I will like to refer to the MMDR Act. MMDR Act. Okay. Mineral and Concession Rule 1960. Rule 22D.
Rule
22D.
capital D.
Capital D, Your Lordship.
Okay.
Minimum area for grant of mining lease shall not be less than 1 hectare in respect of small deposit.
1 second, 1 second. (22D). Minimum size mining lease, yes.
Yeah, minimum size of mining lease, Your Lordship.
Yes.
1 hectare in respect of small deposit. Clause B, 2 hectare in respect of beach, sand, or treasure. C, 4 hectare in respect of all mineral deposit other than those specified in clause A and B. Your Lordship, I would like to refer to the 7th schedule to the Constitution of India, entry 54. Only 3 points remaining, Your Lordship.
2-3 points only.
Yeah. 7th schedule to Constitution of India, entry 54.
State list, union list.
Regulation of mine and mineral development to the extent to which such regulation and development under the control of union is declared by parliament by law to be expedient in the public interest.
Entry 54 union list.
State list, entry 23, Your Lordship.
If entry 54 union list, deliberations on the Jackson, so yes. Then state list entry number
Entry 23.
23.
Yes. Regulation of mine and mineral development subject to provision of List 1 with respect to regulation and development under the control of the Union.
Yes.
According to the term of reference for, not this one, no? So my point is that 100 hectare is fixed without basis of law, illegal, unjustified, and discriminatory.
Yes. I forgot what was the justification? Subordinate legislation.
Subordinate legislation I have stated earlier, Your Lordship.
Yes.
I have submitted earlier that subordinate legislation should be within the ambit of the law, cannot go beyond the statute. And in this case, the law does not prescribe.
What about section 5(1)(b) of the MMDR Act?
Section 5B,
5(1)(b).
1B.
Yes.
Those are conditions, but 100 hectare is not, is again the provision of the section 6, your lordship.
5.
1B.
It talks about restrictions on the grant of prospecting licenses.
Yes.
Mine is correct.
Yes.
Yes. Now
We
5.
don't have any problem
Now,
with
now
other
state
issues.
governments just read this. Now, you read 5. Section 5 says, a state government shall not grant a mineral concession to any person
Yes.
unless such person, okay, A, Indian nationals, or B, satisfies such conditions and be prescribed. Now, will this...
And this condition,
see, this,
section
now
100.
this condition 5(1)(b) says that now the state government can prescribe what conditions that need to be, whatever conditions.
Those are
So they say
not
that
condition.
now they are deriving the power from this provision of the MDR Act that says that
these
the restrictions on grant of prospecting licenses or mining leases is subject to that you satisfy the conditions as we prescribe. And they say that, if I remember correctly, the condition that the state prescribes is that it should not be less than 100 hectares. Correct? So whether you have to show that, how is that, if they are given this power, whether the condition is unreasonable.
Your lordship, the condition prescribing 100 hectare is in direct conflict with section 6, your lordship. So it is not in power.
Sorry. Those mineral concession rules are made under the Act, correct?
Yes.
The mineral concession rules are different. Now the Act says itself at section 5 that such condition may prescribe. That's the only thing that is in the mind of the court. Whether you have any case or not. Only because whether this condition, the Act gives them the power. And whether this power to prescribe this minimum or maximum area is, it militates against the scheme of the Parent Act. There, whether it's not a piece of legislation, but whether whatever prescription or whatever requirements they've made, whether it militates or violates the, what the Parent Act contemplates with regard to prescription of maximum area and minimum area, as you see, like by the MDR Act, maximum area is given, and by the rules, the minimum area is given.
Your lordship.
So rule says that you can't give for less than 1 hectare, or fragmented, so on and so forth. That's fine. You have no problem with that. Yes. Now you say areas how much?
100.
Your area is how much? Your area
Oh,
that is seeking 7 hectares.
hectare.
Right. So that's the only thing. Yes.
And this provision satisfies condition as may be prescribed. This cannot go beyond the.
You have to show that they satisfy the court that this cannot go beyond. That's what. The one paragraph let's see in the old Dimasa case.
Last.
One second. Just let my train of thought not get disturbed. Now, see para 91 of that Dimasa judgment which you quoted.
Yes.
You read it at page 238.
Yeah.
Just read para 91. Which one? It refers to what I said just now.
Yes.
Just read it. Can you read it?
Yeah.
91.
91, yeah.
Yes, just read it.
When under a parliamentary enactment, the state has been given some statutory obligation, there is no lack of jurisdiction in the state to frame policy to give effect and implement the jurisdiction conferred on the state by parliamentary enactment. It is true that mining policy to be framed by the state has to be confined to the jurisdiction conferred on it as per the MMDR Act and the rule framed there under. There are no other issues.
There are other.
There are other related issue concerning mining, like protection of environment, forest, for which the state has to declare its policy or implementation of its objective. Several other aspects relating to mining, like rehabilitation, reclaiming, restoration, have to be effectively implemented by state government, for which also it may be required to frame policy. We may further notice that the Meghalaya mine and mineral policy was already framed by the state government, even before direction were issued by NGT. In pursuant of NGT direction, it was drafted guideline in 2015, which was prepared by the state of Meghalaya. We thus, of the opinion direction of the NGT to declare mining policy by the state of Meghalaya cannot be said to be without jurisdiction. However, the state
Very important. How the state in the mining policy can include where
can only include those areas. However, the state in mining can include only those areas where it has jurisdiction under the MMDR Act and the rule from there under.
Now, see, you read that section 5.
Yeah.
Please listen. You read section 5, 1B of the MMDR Act, correct?
Yeah.
That vests jurisdiction on the state government to prescribe some directions. Okay. Now, your judgment only, para 91.
91 is
speak about the same thing.
It's
now
of
how
environment.
same thing. Now, how are you seeing eventually in your case that the action of the state government in prescribing this one is unjustified? It goes on facts or whatever, but then on point of law, you cannot say that they don't have the legal the competency or the competency to make this prescription of 100 hectares. Now, I agree. Do they have the competency or not? Do you agree? Do they have the competency?
My belief is that they don't have competency.
The competency is there. You've not been able to meet that 0.51B and this para 91 of the All-Dimasa judgment.
Because here in 91...
Regarding denuding of powers of the district councils and the state government, that's a different aspect altogether. That has been dealt with the judgment also. They're denuded. But with regard to the exception that's been carved by the enactment itself, that 51B has given this jurisdiction of competency to the state government, and in furtherance of this of 51B, and also what's been in this para 91, I think they have made this policy that no mining lease or prospecting license shall be issued to any person for an area which is below 100 hectares. So, do you say that they don't have the competency?
In my humble opinion, they don't have the.
You give the court the reason then. If you have to meet, you have to meet the 2 points.
Of Section 6, Your Lordship.
Section 6 is the mineral concession rules which are made under the parent act. See, rules are made under an act.
Yeah. But this rule is not made under Section 5, Your Lordship.
Section 6,
the power vested on the state government, the competence has been given subject to such, policy, whatever the state government make. Now, maybe a court agrees with you that for small landowners who have only 5 hectares or 10 hectares, they are being discriminated against in the sense that they'll not be able to apply for prospecting license to excavate or to take out the coal from their land. Correct?
Yes.
But then you have to show to the court that this policy decision is wrong, that the decision-making process is wrong, that's not under the legislative competency or any other executive competency by which they have made this policy. That's what it should have court. And if you show that it is violative of this, then take the order. Finish. Show me the law, you take the order. But first you have to show me the law.
Sir, Your Lordship, I have referred to AIR 1961.
We will not go to 61. We will not go to 61. We just go under those 2 queries of the court only. Whether the action of the state government can be said to be beyond the scope of Section 51B of the MMDR Act. Simple as that.
In my humble opinion, it is beyond.
It's not your opinion, it will be a submission. Your opinion is we are a court, yes.
Yeah, my submission.
Yes.
My submission is beyond the competency of.
Yes.
Yeah.
You see, it's violative. But you justify it. You've read All-Dimasa. You're very familiar with the judgment.
Yeah.
In fact,
When the
In fact, if I
contempt
might
of-
share with all the members, I was, a party to this decision also, although I was elevated before judgment was rendered. But I appeared in this case on many occasions with Supreme Court. Yes. So you meet the points, I'll give you, let him have another chance, Mr. Attorney General, let him meet the points. That's his answer that only 5.B and the para 91 ultima sir. And show that
one section you
it's wrong,
one
yes?
section your lordship and section 6 your lordship. My friend is referring to section 6 of MMDR Act. And
No, MDR, it's
section
referring section to rule 6 of the
No, my
Procedural
lord,
rule.
section 6. He is referring to maximum area in section 6, my lord. Section
maximum
6 of
area will
MMDR
come
Act.
into play.
So maximum area will not come. It's a maximum area. It is not talking
No,
about minimum
prescription.
area.
Prescription MDR is only for maximum area, not for minimum area.
Maximum area.
Minimum area comes
Yes.
with the rule. You prepare.
Yeah.
You kindly prepare and then you assist the court.
Yeah.
Because the court wants to come to a finding which which is
highly obliged.
yes. 61 judgment you talk about subordinate litigation.
Yeah.
Yeah, that's... Yes, we can after lunch. Whoever has urgent hearing. Or only have urgency to adjourn. You have urgent matter to take up after lunch if necessary.
Lordship, there was one matter, item 25. My friend Ms. Ayn is also online.
Yes.
Will take some time. If
It's very interesting matters today, that's why. Yes.
Item 25, we were wondering it can be taken on another day because
Yes.
time is running short.
My lord, I have no objection.
So Monday, if that is convenient.
Monday absolutely out. Can be Tuesday only.
Tuesday.
Yes. Because this court, for reasons beyond the court control, we have to travel also to attend something.
Item 24, my lord, the lordships may have it after 2 weeks, my lord.
Who's for the sign?
Mr.
Mr. Gupta always accommodates. Doesn't have a problem. Yes, Mr. Nonkala. Any urgency?
Not really.
Okay, 2 weeks is. That's it.
Maybe lordship.
Yes, Mr. Kumar.
My lord, item number 33, my lord.
Yeah.
Maybe taken after 2 weeks, my lord.
Okay, 2 weeks, 33. What about 27, Mr. Chair? After lunch?
Maybe let it be taken up on 17, your lordship.
No, 7. You can't log it.
Then 24, your lordship. 24.
27 is Dr. Muzika. You're there, 27.
Let it be on 24, then, your lordship.
Okay, 24th, yes.
Lordship. Obliged.
What about 30 ready?
Please, lordship.
Mr. Suna.
Not this
Mr.
matter.
Shongwan, sorry.
Lord, this matter has already been heard. In the course of the hearing, the state government has filed the affidavit bringing on record regarding the formation of the managing committee. There's nothing much left also to argue now. If
Then
this-
what is fructuous?
No, not infractions.
There is a stay, lordship. Will happen some other day, your lordship.
Next week, Lord.
Why are all the lawyers allergic to after hearing after lunch? The other day was ready before till 4:15. But everyone, and the other day, the saddest part is after putting a matter at 2:15, when started, then the consul said, I'm suddenly not feeling well.
It seems your lordship
So,
it has become a established convention, your lordship, that
Commission not coming out after 2 o'clock. I don't know.
Some other day, your lordship, that
next week. This
Are you suffering or you're enjoying a stay order?
Partly
Yeah,
we are
yes.
enjoying, partly we are suffering also. because-
Enjoying doesn't matter, then 2 weeks is.
obliged, your lordship.
30, 31 connected. 31.
30, 31, your lordship.
If possible, my lord, next week, because this
Next week a bit tight because Monday we'll have a very truncated sitting, then 17, 18th holiday. That's the thing. Yes.
Obliged, lordship.
1 week, then take it. We try to take it in the week beginning 23rd.
Lord, earlier it was in the admission hearing, my lord, but later on was shifted to the hearing after hearing on that day.
But that means not, there was never posted formally for hearing.
No, my lord, it was in the admission hearing.
And
this
listed
matter also-
next week, admission hearing. Admission hearing.
Obliged.
No other matter for two.
It has become an established convention.
It is not a convention, is not enforceable in law.
For the lawyers,
We'll start that. We'll start that culture here. And after we'll fix hearings. Maybe I was talking to my brother judge. I said, since they're so reluctant, let's make the motions at, we have the hearings in the first half and we do the motion at 2:15. Motion on part 1, we'll do 2:15. I think it'll be better. So then that way we'll all be here for the hearings, we'll do them, and 2:15 we'll be ready for the motions also. Yes. Yes, madam.
What you